he also submits that the state of Assam cannot be a party in this case, and instead it should be the NCB. Then who will file the
Objection.
We'll file also.
It's clear.
the amended cost title?
Not appellant in item number 3.
Manojit Bhuiyan,
Manojit Biswas.
Manojit Biswas will file. I think she's.
No, but Manojit Biswas is in item 3.
Yes,
There's no one in item 4. They are the legal aid counsel. Who will file?
I think last occasion, Manojit Biswas took time to file amended petition,
Not in item 4,
not in item 4.
because he's not the counsel in item 4. Item 4 is they are
Hmm.
represented by the legal aid counsel. Now a proper.
The registry has to do it in respect of item 4.
Registry is directed to. Substitute the present cost title in criminal AJ 91 of 22 by making an amended cost title impleading the Narcotics Control Bureau bracket NCB, Guwahati zonal unit as a party respondent instead of the state of Assam. Registry is also directed to serve a copy of the paper book to Mr. SCKL in criminal AJ 91 of 2020.
The only predicament is that my name is reflected, that I'll file my objection. So that can be corrected.
Stop. Next para, you're right. In the IA, sir, that there is one IA, you're right. Mr. SCKL, standing counsel NCB, shall file written objection within
2 weeks. Sir.
2 weeks. This is the matter after the meeting.
Please, Mr. Lordship. Lordship, for item number 3, can the matter be passed over for time?
3,
Yes.
we have adjourned the matter. You want to hear it? We can hear it. Item 3,
He was supposed to file IA for correction of the cost.
correct. Okay, make that in item 4 only. Item 3, just wait. Actually, 3 and 4 are together. That's the
Together.
problem.
There are 2 accused.
But where is he?
He's appearing in other court, Lordship. That's why he told to pass over the matter for timing.
To say what? To say that he wants time to file the amended cost title. You don't know.
Yes.
Okay, you wait. Let the order remain, but we'll wait.
Obliged, Lord.
Lordship, in this case, my friend has just informed me there is some new development, Lordship. A fresh appointment order has been issued to him in the month of May, 12th of May, Lordship. I am not aware that, let me take instruction to that. Let it be fixed on Monday, Lordship.
What fresh appointment order?
No, Lordship, what happened? I was a departmental candidate of DRT in Odisha.
No, what fresh appointment order? Order dated?
Lordship, what happened during the pendency of the OA before that they relieved me. Then I approached the Calcutta Tribunal, the president. Again, I was appointed in the same capacity, in the same post at Guwahati, on the same post.
On what basis? Deputation or what?
No, Lordship, actually, I cannot be in deputation because I am a departmental candidate. And advertisement reflects that any departmental candidate, they will be, their appointment will be treated as a promotion. I was
No,
working in-
but then earlier in point of time, they are saying that the DRT were all different. I mean, all
Lordship,
different.
Only
Lordship,
only
because
one
of
section will clarify everything, Lordship. Section 3 of the
If they were all
DRT
different,
Act, Lordship.
if they were all different,
Yes, Lordship.
how can you say that
No, Lordship.
Katak DRT personnel will
No,
be a
Lordship.
departmental candidate in this Guwahati DRT?
Lordship, may please to see advertisement Lordship.
Page,
Page 21,
Page 21, Lordship.
yes.
Then let me begin, Lordship.
note number 2.
If you so, I am ready to begin.
And Lordship, there is a justification by the tribunal while passing the order, Lordship.
Maybe, but then the reason it has come here is to see whether the justification is sustainable or not.
Now, Lordship, may please to see note 2 for the post of
Which page, which page?
page 21,
21,
column 2.
Huh?
Column 2,
column 2, where is the column? Huh?
Note
note
two.
number 2.
Note 2.
Note number 2
Note number,
in second column, Lordship.
second call. Page 21, this is the one, this,
Advertisement, from advertisement.
Yes, Lordship. Advertisement.
column number 2 is, okay, note number 2, yes.
For the post of section officer, departmental candidates having requisite qualification shall also be considered along with the outsiders. And in case the departmental candidate is selected, the post will be treated as to have been filled by promotion, Lord.
Now, you see, what do you mean by departmental candidate?
Because I was working in
Cuttack.
as an assistant in DRT Odisha, Cuttack, Lord.
Ah,
Then advertisement was plotted by the DRT.
in Guwahati.
I applied through proper channel.
Ah. Now you just tell me one thing.
Lord.
Supposing that that time, forget now, at that time, if there was a promotional post in Bombay, DRC, you mean to say, yeah, all the persons in all the DRTs all over India would have a right to be considered for that post?
No, Lordship, what happened? At the relevant time, there was a separate rule for different tribunals. But subsequently, service rule was plotted, Lord.
When was that? When did that common rule come into play?
Yes, Lord. It is
2018.
Into effect, huh?
2018.
Which date?
2018.
2018.
Yes, Lord.
And you were promoted on and you were appointed to that post on what date?
2017.
Then?
No,
How
Lordship.
can you apply
No,
a
Lordship.
prospective at that time that you were appointed?
Lordship.
That rule was not in force.
Now, Lordship may please to see. I'm relying on one judgment of Honorable Supreme Court
Ah.
where deputation has been explained.
Deputation has been explained.
Lordship.
Correct.
It cannot be from if the deputation is there, that it must be from outside the cadre to different
Correct.
department.
Correct. It has to be from outside.
I'm in the same department, Lord.
How can
Yeah.
you be in the same department?
Because Lordship DRT Calcutta.
We see, is there at that time, was there a common seniority list for all the personnel for all the DRTs all over India? Or was the DRT for Cuttack having a separate seniority list?
Lordship may please to see the reasoning, Lordship.
Okay, I've seen the reasoning. Doesn't seem to be that I have not been able to understand. We have not been able to understand. Yes, sure. Yeah,
Lordship may come to page 136,
yes,
paragraph 4.
yes.
It has been stated by the applicant that in the said notification, though as the direct recruitment, however, the post was declared to be filled up from the eligible different
In
states.
the said, though as direct recruitment, however,
Yes.
the post was declared to be filled up from eligible
And the employees on deputation basis in number 2.
on
which I-
deputation basis.
Yes. Lordship, in my case, yes, it was deputation for other candidates, not for the departmental candidates.
Because according to you, you are a departmental candidate.
Yes, Lordship. I am working as a assistant in the DRT Cuttack, Lordship.
So
I
if
applied-
you, so that means, Mr. Counselor, what you mean to say is that all the assistants working in all the DRTs all over India,
If they have applied,
if they have applied, they can be promoted.
Lordship, yes,
Do you, for
because the-
promotion, do you have to apply?
Lordship,
Where's
service
the
rule-
rules for, show me the rules
Lordship,
by which a person has to apply for being promoted.
Lordship. And
That was enforced.
earlier rules also, Earlier service rule also provides for promotion
I
from
need-
the
I need
assistant to
a-
the section, to the section
I
officer.
need paper to write. There's no paper here today.
Go to lower side. Go to the next section.
What is the page again? That advertisement page?
Lordship,
21.
21.
21.
Lordship has to come from the beginning, Lordship. May I just read? Application are invited from eligible
No, no,
candidate.
let us read together. Which page? 21.
21.
21, yes. It's, please
From the
read.
beginning, from the beginning.
Yes, yes, yes.
Application are invited from
Just a minute,
eligible
just a minute.
candidate not exceeding
Just a minute. Just a minute.
Lordship,
Yes. Okay, now you can start.
not exceeding 56 years of age
Applications are invited for not exceeding, yes.
with requisite qualifications for filling up the following
On
post on
deputation.
deputation basis. Lordship, kindly see his appointment order, next page, Lordship.
No, no, just carry on reading.
Under Debts Recovery Tribunal, Guwahati, last dated so and so, this section officer. Only on the note, Lordship, it is stated
So
that
it is for the section officers. post.
section officer.
Then what does the note say?
Note one say, the period of deputation so and so, he is relying on note two.
For the post of section officer, departmental candidates having requisite qualifications shall also be considered along with outsiders.
Lordship. Yes.
Along, but this is along with outsiders.
Outside.
Admittedly, I am departmental candidate laws.
And in case the departmental candidate said the post will be treated to have been filled up by post.
Promotion.
What is this? What is this along with outsiders?
Outsider, he is an outsider.
Then
He
he
could have
comes,
come.
he comes
but
under
the
note two.
departmental candidate, if it is open for Lordship, but the very basis of appointment is on deputation basis. That has been stated on the top, Lordship. Can you see his appointment order or Lordship? Next page,
No, no. Please read note two carefully.
not two.
For the post of section officer, departmental candidates having requisite qualification shall also be considered.
Now, those who are working on the DRT Guwahati, they could have also applied for it. In that case, their promotion, their
Mr.
appointment would be.
Then one by one, what's the hurry? Along with outsiders, please,
He
please,
came as an outsider.
Huh?
He
he's
came as a-
outsider.
That's mean for the departmental candidate only. When someone from DRT Guwahati apply Lordship, he will be considered as a departmental candidate.
Yes, correct.
Lordship.
But then this outsider,
In that case, the
You-
the DRT candidate from.
this outsider also is given the same weightage or the same benefits as the departmental candidate. It appears so.
In my humble subject, that.
Now, let us, maybe, but let us see what is your understanding of the words along with outsiders. Who does it relate to?
Outside is anyone from other than the DRT Guwahati Lordship.
So any other DRT personnel from any other DRT.
Lordship, may come to his appointment order, next page, Lordship.
Before. If along with outsiders is to come here, then there was no need of mentioning this along with. No need, there is just rule of play of can be also can also be considered and in case along with outsiders because. Yes.
Lordship, even he exercised option and was drawing deputation allowance.
Huh?
He exercised option and was drawing deputation allowance, page 23.
Maybe that is a different thing. The thing is that what is the, you see, these words along with outsiders, why did you put it in? What was the need? What was the requirement of putting it in? If it is not your interpretation that these words cannot be put these persons cannot be put in the same, status as those of departmental, officers. What was the requirement? You could have done away with this.
In case if someone from Guwahati would have applied for them only, it will be considered along with the outside of Lordship. Lordship,
No,
one, Lordship must come to section 3 of the DRT Act. That each of the DRT are separate entity, that will make it clear, Lordship.
Give us section 3, DRT Act.
May I just read slowly, Lordship.
Let us get the, thing also. The act.
It would come together.
Didn't you give the list of, acts that are required?
It will become a चाहिए.
No, this is a surface act. Just give it.
May I
Huh?
just read slowly, Lordship.
A surface act, what are you reading?
No, so recovery of debt due to banks and
Yeah, just
financial.
give me that.
It's
Just give me that.
it's included all the acts applicable to the.
Huh? Recovery of? No, just show him the book. Then you should have given a list prior to the, start of the, court proceeding.
DRT
Yeah, show
also,
me, but which one?
DRT Act is also there, Lordship, along with the other act.
No problem, no problem. The recovery of, that is not here. But that is not here, this is not here. This thing is not here.
It is support. No, move to support, move it up.
That is his copy. But where is your copy? There are two of us.
Lordship.
If you have to
Lordship,
give. I haven't got. This from the recovery, it's not here, it's not in this act. Out here, there are around 5 acts, or 5 rules and acts. Out here, there are around more than 10. There's a different book.
Subsection 2, Lordship. Of 3. The territorial jurisdiction is there, Lordship.
No, you see, this is all right. But what do you mean with the words, along with outsiders? What is this?
Lordship, in my respect, so that doesn't give him any mileage to that, Lordship.
Mr.
outside.
Counselor, I'm not asking whether it's a, what is your view on that? We are asking
My-
you,
my-
we are
my-
asking you,
My interpretation will be, Lordship, that if the departmental consider also apply along with others
you
outside.
see, you please bring the records with regard to with regard to the basis for making this advertisement.
Lordship.
That will clarify as to how, along with the words, along with outsiders, came to be inserted in this note 2. And who does it specify? Who does it mean? Who does it
Yes.
cover?
Let me get that
Ah,
clarification.
so that once you get that's the end of the matter.
In
right.
any case, Lordship, his appointment order very specifically said his period of 3 years on deputation basis.
No, that may be. You see, but the thing is that
Hmm.
once he is entitled to be appointed in a certain manner in terms of the advertisement, then he has to be appointed in that manner.
Once he has
You-
been accepted also, Lordship.
Maybe
whether
he
can turn back
accept-
Now.
No.
Having accepted the deputation allowance also.
He will give back everything
That has been,
with interest
that has been recovered from my salary loss.
or recovered.
Yes, sir.
Already.
Yes, already recovered.
Or recovered.
And the,
Anyway, that is not
That
the
will not-
issue. That is a subsequent thing. We have to go to the basic fact. There is whether this advertisement, note 2, includes him, that's all. If it doesn't include him, then it's end of the matter. So you just show us the record on the basis of which you made the advertisement specifically with relation to note 2 and who does its who is it referring to this note?
That we
That's
clarify.
Okay, right. Heard Mr. B. Chakrabarti, learned counsel for the learned CGC for the appellant, for the petitioner, for the petitioner. And Mr. S.C.K. learned counsel for the respondent slash caveator. The appellant is agreed with the order dated with the impugned order dated 24/4/2023 passed by the Central Administrative Tribunal, Guwahati Bench. In original application number 040/00375/2019 with misapplication number 040/00055/2022. No, wherein the learned tribunal has directed the writ petitioner to treat the appointment of the respondent as section officer to be an appointment on promotion and not deputation. Next paragraph. The case of the appellant,
Petitioner.
the case of the writ petitioner is that an advertisement dated what is the advertisement dated?
30 May to 5 June 2000.
30/05/2015 had been issued for filling up the post of section officer under the DRT, Guwahati on deputation basis. The respondent being successful in the selection process, he was appointed as section officer on deputation basis, by order dated
21 to 2017.
21/2/2017. However, the respondent submitted a representation. Correct? Did you submit a representation dated?
Uh, Lordship, you will find we rejected Lordship at,
Huh?
we rejected at page,
No, submitted a representation to,
which was rejected Lordship, we will find page 66.
where is his representation?
That has not been annexed here. But it was part of his OA. It was part of his OA.
It is not visible. Annexure 6, page 53 lots.
Lordship.
Submitted representation dated,
29/5/19.
29,
5/19. Lordship.
29/5/19. requesting that his appointment to the post of section officer should be considered as an appointment on promotion and not on deputation. The petitioner's representation being rejected, the petitioner filed OA 040/375/2019 before the learned tribunal. The learned tribunal, by the impugned order dated 24/4/2020, allowed the respondents prayer and accordingly directed the writ petitioner to treat the petitioner's, the respondent's appointment as section officer as appointment on promotion and not on deputation. Next paragraph. On considering the submissions of the councils, we are of the view that the original records need to be looked into to ascertain the reasons for insertion of the words along with outsiders, invert comma, along with outsiders, which has been reflected in note 2 of the said advertisement. Next para, note 2 of the said advertisement states as follows. That is at page 21. It's in red, okay? Let's see, huh? Okay, I'll read it. Note 2, right? For the post of section officer, departmental candidates having requisite qualification shall also be considered along with outsiders. And in case the departmental candidate is selected, the post will be treated to have been filled up by promotion. Full stop. You got it? Invert commas close. Full stop. The above note 2 has specifically laid down that if departmental candidates are selected, their appointment would be by way of promotion to the post of section officer, while the selection of the candidates who are not departmental candidates would be on deputation basis. Full stop. Next para. The case of the respondent is that he was serving as assistant in the DRT Cuttack. And as such, he has to be treated as a departmental candidate. On the other hand, the case of the writ petitioner is that in view of section
3 subsection 2.
3(2) of the Recovery of Debts Due to Banks and Financial Institutions Act, 1993. The respondent could not have been treated to be a departmental candidate. Full stop.
And also in view of the
Bracket.
that existed till 2001 rule.
What exists?
As that prior to 2018 rules law.
That's we're not on that. That has got no relation to this case in that. Right. Section 3(2) of the 1993 Act, hereinafter is that. States as follows. The central government shall also specify. I am putting all this down so that next time it becomes easy. That's the only thing. The central government shall also specify, in the notification referred to in subsection 1, the areas within which the tribunal may exercise jurisdiction for entertaining and deciding the applications filed before it. Invert commas close. So I'll just read it again, huh? The central government shall also specify, comma, in the notification referred to in subsection 1, comma, the areas within which the tribunal may exercise jurisdiction for entertaining and deciding the applications filed before it. Full stop. Inverted commas. Now, where is this notification?
That has
Next. Thus, in view of the issues stated above, comma, it is incumbent on the writ petitioner to produce the records pertaining to the notification issued in pursuance to section 3(2) of the 1993 Act. Full stop. Further, the official record should also indicate as to the basis for insertion of the words along with outsiders, along with outsiders in note 2 of the advertisement, and with regard to which particular class of persons the said words were to be made applicable to. When do you want? Anytime, you just have to bring the original record, that's all, with the
Next.
notification.
next Wednesday, Lordship,
Last day,
not 28.
yeah, okay. Okay, list the matter on Wednesday.
I have not been paid my salary for the month of May also.
That's a different issue. You will get in lump sum. If you succeed, you'll get everything. But why are you not paying him?
Lordship, I don't have the instance. I will tell you.
You have to write instruction, you write. Mr. B. Chakrabarti shall in the meantime obtain instructions as to why the respondent is not being paid his instruction, his salary from
May,
May 2023, comma, as has been submitted by Mr. S.C. Kal, learned counsel for the respondent. This is the matter on 28th. In view of Mr. S.C. Kal appearing for the caveator, the caveat stands discharged. You take your book also. Next time, please give a prior intimation. We don't have it, they don't have it.
there is a recruitment rule also 2001 laws. That is also,
Oh, yes, okay, the Mr. B. Chakrabarti shall also bring the recruitment rules of 2021 on the next day.
2001.
2001, 2011, 2011,
There are two,
2000.
earlier it was 2001. Thereafter, phase rule was framed and that is 2008.
Then it's not required, the last step. 2018 is not required. Where is the question of 2018? You are appointed in 2017. That time there was nothing.
2001 rule will be applicable in my case. There is also clear law.
Yes,
I'm going to the response number 1.
we are ready for response number 1.
My friend had challenged the order.
Sole
of
sole
Huh?
respondent.
Huh?
Sole respondent, Lordship.
What is the case?
Case is, Lordship, is an appointment, Lordship, new appointment.
So what is wrong?
So, Lordship, you have been here against the judgment of the CAT, Lordship.
So what is wrong with the judgment?
Wrong is, Lordship, there is a two mark sheet produced, Lordship.
Huh?
The petition, the respondent produced two mark sheet, Lordship.
Correct.
At the time of application,
At the time of submission of the application,
Application.
the wrong mark sheet was, but at the time when, at the time of
Hmm.
verification,
We
the
should-
correct mark sheet was brought.
she show another certificate.
which has been verified to be true.
But at the time of application,
That was a mistake.
that is being kept mum.
That was a mistake. Why should she suffer? Human beings are prone to mistakes. They make mistake. Supposing in my class 10 certificate, supposing I get 90 marks, average of 90 marks. No person in his right mind will submit a mark sheet showing that he has got 70 marks or 50 marks or 60 marks. He will give the right mark sheet in which he has got 90 marks. Unfortunately, he made a mistake in submitting a mark sheet in which he had got less marks. That's all.
Only thing is, Lordship, the action should be to immediate.
Huh?
That action should be immediate
No, you see,
because at the time
this
of-
aspect has already been
it
taken
is
care of.
after 8 years.
Huh?
It is after 8 years.
What has been after 8 years?
After 8 years, she found that it is a wrong.
After 8 years, she found it was wrong. But it was a mistake. You just give me the facts of the case. Tell me the facts of the case. What are the facts of the case? What are the facts of the case?
It's page number 12, para 13, Lordship.
In fact, my lord, page number 70 of the judgment of the cat, in paragraph 2, it makes it a bit.
No. Just give me the advertisement. You give me the entire facts from A to Z.
Advertisement.
I have gone to the root of the issue. You know, the haddi is there, the bone is there. Now give me the flesh to fill up the gaps here and there and to make it in a proper order.
Only Lordship is correct. Lordship may consider the candidature of this candidate, Lordship. But only thing is that if the authority found later on it is incorrect, then the authority will decide.
You have already done it. The tribunal has already done it. That the board has been made a party, and they have been, I think, twice they have given even here.
Genuine. This is mark is genuine. They have written a letter.
Correct.
Thereafter,
The board wanted to, the tribunal wanted to know whether the document certificate that had been brought at the time of verification of document
That is correct, Lordship.
was correct or not.
Yeah.
And accordingly it asked for the expert opinion. Expert opinion said it's correct. Now, why should the poor person be penalized for a mistake that has occurred? I can understand your case if she had given, she had given 100 marks showing a certificate showing 100 marks, and at time of verification she brings 50 marks. But here is the case where she made a mistake. She gave a certificate showing that she had lower marks, but actually she had got much higher marks, and which was brought to the notice of everyone at the time of document verification.
Actually, original cases, Lordship, actually, the matriculation certificate is not required in this case. The applicant should have to pass minimum 8 pass. 8 standard.
But what was the, yes, so
But what the candidate mistakenly shown the matriculation certificate, and that too also in wrong way. That is the case, nothing else, Lordship. Lordship may consider the case.
that was a mistake.
Lordship may consider the case, no problem.
in fact, my lord, I have the
Huh?
minimum qualification of this part. This 8 is 8 marks. 8 standard.
Huh?
Additional 8 standard. Minimum qualification of
That
as per the
also.
advertisement. Thereafter, in additional affidavit, I have given the my 8 pass certificate also I have given. If Lordship take up my additional affidavit, there is
So there is,
Nothing, my lord.
there is nothing here. in
Nothing,
this
my lord. In
petition.
fact, my lord, I have prepared a list of dates. If I want to.
No, no, I can give you a list of dates.
So, you know, I want one sheet of paper.
Give a mark. Yeah, this could be a more time you look over. So I can understand that case if the put of gave up. But then later on, a document verification. Then there is a. Photo also photo rectification. Photo justification. I cannot go. What is this education? By the owner of a company. What education? Heard. Mr. K Day, Leonard
DK.
Count,
Decade,
huh?
decade.
DK Day. Leonard CGC, over,
Railway, railway,
Leonard CGC, Leonard Council, Standing Council
railway.
for the railways. And Mr. S. Bora
Correspond number one.
for the,
Respond number one.
who is two?
Who is the Bihar Shiksha? Bihar.
The one who
Who
verifies the document.
And he has given the certificate.
I have, out here, they have not filed any
And out here they have-
affidavit. They filed it there in the,
Yeah.
yeah.
Okay.
No one appears for the respond number two. Mustafa. This is a. This writ petition has been filed. Against the order dated.
No, you'll find the order in page number 69. Order dated 19/11.
Where do you get the 1911?
Page 69.
It doesn't say that.
Yes, in the top, my lord.
Huh?
Order dated 19.
Okay, yes. Order dated 19/11/2019. Passed by the Central Administrative Tribunal, Guwahati Bench. In original application number 040 slash 00027/2015. By which the railway authorities were directed to process and finalize the appointment of the respondent number one in a group D post against employment notice number 01/2008 bracket group D bracket close group D as the respondent number one had already been selected earlier. Question. The facts of the case is that your synopsis is as big as big as the appeal, the writ petition, huh? Four pages. Is that pursuant to an employment notice, pursuant to the employment notice number 01/2008 bracket group D bracket close, inviting applications to fill up group D post, comma. The applicant took part in the selection process. Question. after passing the written examination, the, no, say applicant, respond number one, huh? After passing the written examination, the respondent number one was called for document verification. First step. However, in the process, however, during document verification, comma, the candidature of the respondent number two was disqualified on the ground that the what is it? On the ground that at the time of submission of her application, comma, the respondent number two had attached a copy of the mark sheet. Which mark sheet? Last 10 mark sheet.
No, HSLC pass.
Huh?
HSLC
Had
pass. Mark one name.
had attached a copy of the HSLC mark
Mark.
sheet, securing second division against certificate bearing number 3452 dated 9/7/2004. Full stop. However, during the document verification, comma, the respondent number one had had produced certificate and had produced mark sheet bearing number what is the number? Huh? 3410 dated 26/9/2012, showing that the respondent number one had secured the first division. As the subsequent mark sheet bearing number 3410 dated 26/9/2012 was disputed by the writ petitioners, comma, the candidature of the respondent number two was disqualified. Full stop. Next paragraph. Agreed by the same, agreed by the above action of the respondent, writ petitioners, comma. The respondent number one filed OA number 040/0027/2015 before the learned tribunal. In view of the writ petitioners not accepting the mark sheet bearing number 3410 dated 26/9/2012, produced by the respondent number one at the time of document verification, comma, as the same was not, as the same was different from the mark sheet produced by the respondent number two, at respondent number one, at the time of submission of her application, comma. The learned tribunal impleaded the secretary, comma, Bihar Sanskrit Shiksha Board in the case before the learned tribunal. The secretary Bihar Sanskrit Shiksha Board thereafter submitted a letter dated 12/6/2019 stating that they had verified the mark sheet bearing number 3410 dated 26/9/2012 and found the same to be genuine. Awesome. As the respondent number 2 was found to have qualified in PET means
Physical aptitude test, my lord.
in the physical aptitude test. Physical,
Respondent number one, not two.
respond number, physical
Aptitude test.
aptitude. E can be aptitude,
No, physical. What's the particular word is
physical efficiency test,
physical efficiency test.
bracket PET.
Mm.
And in the written test, comma, besides the mark sheet bearing number 3410 dated 26/9/2012, having been found to be genuine, comma, the learned tribunal directed the writ petitioners to process and finalize the appointment of the respondent number 1 in a Group D post in pursuance to the employment notice number 01/2008 bracket Group D, comma, within a period of 2 months, comma, as she had already been selected. Selected?
Yes, sir.
Next. So what have you got to say? What is the submission? We will record anything to say?
If the authority let her to give appointment, but after that, if the authority found any discrepancy with the certificate, then authority have a right to. Take
No,
a-
that is already decided issue. If you want to challenge that in a civil court, that is a different issue. But as on date, there's nothing to show otherwise. Right. The learned counsel for the writ petitioner submits that in future, if the petitioners come to a finding that the mark sheet bearing number 3410 dated 26/9/2012 is a fabricated document, comma, they may be given the liberty to take action on the basis of the same. Correct? That's enough. On hearing the, on hearing the, no, then you say Mr. S. Bora, learned counsel for the respondent submits that the submission of the earlier mark sheet, the submission of the earlier wrong mark sheet by the petitioner, by the respondent number one, was a genuine mistake. And the submission of the correct mark sheet at the time of document verification does not in any manner cause any prejudice to the lead petitioner.
Malak, in fact, Malak, it was not the mistake of the respondent number one. In fact, he was given that mark sheet, that second division. He found out later on when the certificate was issued to him, first
Okay,
certificate,
okay.
that is first division. And the mark sheet was second division. Then the confusion started. Then he got
Okay.
the original certificate.
Okay. So it was actually given to her wrong. Then you cut that. You just say, Mr. S. Bora, learned counsel for the respondent number one, submits that the entire controversy started due to the Bihar Sanskrit Shiksha Board having given the respondent number one the wrong mark sheet,
Wrong person.
wrong mark sheet
Later on, when the certificate was
bearing number 3452 dated 9/7/2004, showing the respondent number two of having secured
second.
second division in the said examination. In the which examination? In the
In the,
In the
class 10,
Madhyama
Madhyama
pass certificate examination.
class 10.
Let's say in the class 10 examination, in the class 10. However, on the respondent number one making inquiries. What?
Respondent number one got the certificate, first certificate in 2012. Then he found in the certificate is first division,
Okay. However, on getting
the first certificate.
the pass certificate and not the mark sheet,
Mark sheet he had received it.
and not the mark sheet which on getting the pass certificate, which is different from the mark sheet. In the year 2012, the respondent number one came to learn that she had in fact secured the first division and not the second division.
Then the new mark sheet was taken.
On making inquiries, making inquiries, the Bihar Sanskrit Shiksha Board thereafter furnished the correct mark sheet bearing number 3410 dated 26/9/2012 to the respondent number one, showing that she had secured
Okay.
the first division in the class 10 examination. He accordingly submits that the respondent number one should not be penalized for the mistake committed by the Bihar Sanskrit Shiksha Board. Next paragraph. On considering the factual dispute, on dispute on considering the facts of the case, we are unable to understand as to how any prejudice would be caused to the writ petitioners by the respondent number one furnishing her correct mark sheet, which is in consonance with the pass certificate issued to her. The fact that the mark sheet number 3452 dated 9/7/2004 was mistakenly given to the respondent number one should not be used against the respondent number one. When in fact she had secured a better position as per her correct mark sheet. In view of the reasons stated above, we do not find any ground to interfere with the impugned order dated 19/11/2019 passed by the learned tribunal in OA number 040/00027/2015. The writ petition is accordingly dismissed. Then in the IA, you write in view of the order passed in so and so, in the main case, there is also disposed of accordingly.
Next we'll set a period for appointing her because it will linger.
We have dismissed it, that that thing is there, that thing stand, you file an execution case.
Like,
18C. You are into all kinds.
Lordship, my line of thinking to the better. NDPs are really find it difficult, your lordship. I mean, I have to go through all technicalities. Yesterday also.
We'll all go together, we'll do together, doesn't mean hardly there. There are only
I
4, 5
understand.
provisions,
Yes, my,
not much. Not much.
okay, I'll do.
Only 41, 42,
Yes.
52A.
Yes.
50, that's for search only. Then maybe 54, presumption. 37 is bail. 36 is again presumption.
Lordship
That's
is-
all, there's nothing much.
Quite thorough with the provisions.
No. 20 is ganja, 21 is heroin, and you've got 22 psychotropic. Huh? No, you see, if you can show that he is innocent, then there's hardly any scope for giving bail. Very little chance. You read 37, it's clear. It's like your POCTO and very difficult. He knows the commercial quantity, where is the scope? And this is a case where you have been convicted. So there is no scope for bail in a appeal. Hardly any scope. Very minute, unless you hear the entire matter and say, okay, yes. So we'll dispose of the IA. There's no case. But paper book has to be made. SPR.
The 52A violation I'm talking about, of course, my thinking process is on. I have not reached to any conclusion. But 52A, Lordship will see the heading of the section is for disposal of the
Correct.
contract.
No, the thing is that, you see, I agree with you. You see, there are judgments also made by, which is that violation of the same, not following 52 in its entirety. Does not ipso facto vitiate the entire
Yes,
prosecution
because it
proceeding,
is only when,
prosecution case.
yes, things will be.
So, but then, the way it's taking a turn in the last few years, this 52A, this is the judgment, is becoming a mandatory provision which might affect the prosecution case.
No, Supreme Court said it needs to be followed. They cannot be ignored.
Cannot be. But
But
then what
why-
happens if you do not follow?
But while disposing of the articles, that needs to be followed. Otherwise, inventory, preparation of inventory is not there in any other provision.
No, but then what about sample?
Sample is again 55, it's there for FSF. This is representative sample, not sample for FSF. So I think needs to be interpreted 52A. Which was inserted, of course, in 2000.
I don't know if High Court can now be in that position when Supreme Court is interpreting.
Because otherwise these violations, people go out.
That is there.
But 52A is for a limited purpose. While disposing of the articles, you follow this. Representative sample, inventory, photographs, everything. But this cannot be.
But then
linked.
another thing is that you see 52A, when the inventory is made.
Ah.
Inventory is made. Then it can take the place of the material exhibit also during the trial. Can't it?
But this during the trial, it will not be.
Supposing,
52A is not for during the trial.
no, but the inventory that has been made under 52A.
Hmm.
Can it not replace the material exhibits
Then or it
for the
might not.
purpose of coming to a finding
Hmm.
that a person is guilty? Instead of bringing the material exhibit,
You take
into the court,
representative
the
sample.
inventory that has been made, that can be used.
No, that provision is already there in 42, 43, where after the seizure, they have to list, they have to report it to a superior officer and they have to prepare the list, not inventory, whatever they have seized. So that will suffice. Inventory during the time of disposal. This is what my
No,
thinking
no,
process.
sorry. Sorry.
Regarding
No.
A,
Raj,
52A clause 4.
Huh.
Read clause 4.
Hmm.
where it is-
Representative sample.
No, inventory may be used as evidence. Because you have to dispose of the contraband.
Hmm.
You need not to keep the contraband
Yes, for long.
for long. So if contraband is disposed of, what is to be produced during trial? So 52A clause 4 provides that the inventory may substitute the place of contract. It may be treated as a.
See,
those,
52A, you see, I remember, they used to make seizures of 6,000 kgs of ganja, 3,000 kgs of ganja. Long time back. Now, where are you going to store 6,000 kgs of ganja, 3,000 kgs of ganja?
This-
In fact, when there was a destruction of the confiscated material, I mean, they burnt, how many 10,000 kgs of ganja they burnt. And it was burnt in a far off place
helps to-
near the river. Big pit was dug and it just burned.
I'll
So,
develop that argument.
yes,
Let's
now you can't keep that in the go down.
No. For that, there are other provisions. While seizing, they have to write down whatever they have seized and all.
No, they need not write down at the place of occurrence. They can write down elsewhere
Police
also.
Station also. After bringing it there.
And
So anyway,
that
I'm
that is
developing,
another
let's
aspect.
see.
Anyway, the 389 though I don't find any case.
It'll be.
You want to argue 389? I don't think there's any case for granting of bail. 18C, 20B2C, 21C. There's no case. Mr. Manan, you're there.
I'm sorry, I was
Ha.
basically what your lordship has taken. We are only technical ground. On
Correct.
the basis of these technical grounds, there are judgments. Today I'm not for this. There are judgments of the Honorable Supreme Court that specified on the basically two grounds. That is in section 50 and 42. That if there is some kind of a deviance, then you cannot go for
42 is basically that one is that taking down in writing, giving to the superior officer. and the other is
Quality.
grounds of belief.
So these basically on those grounds. So I think if your lordship, they have.
So
my
you
instruction.
see, so what we'll do is, we'll dispose of the IA. No point keeping it pending. But since the LCR has arrived, we'll ask the paper book to be made. But on the basis of materials here, there's no ground case for suspending the sentence and grant bail.
There is
This
two
is-
sentences.
Ah.
One is for 10 years under section 18C, and the other is 20 years under section 20.
Concurrently,
But they are running concurrent. These are the two sentences. There are 20 years. Huh?
Well,
the hearing can be done, so.
Huh?
The hearing can be done early. After.
hearing can be done anytime the paper book is ready. That is not a problem. We are not running away from hearing. Only problem is we cannot do hearing now in the absence of a
Yeah,
paper.
that is it, because
Now,
we are
who is-
basically on.
We have to be on the same page while he's reading out some evidence. And there's only one LCR. But
But one thing we will do is that we'll point out there are where specifically they have not complied with these sections. If I can point it out from it is the LCR is there or the paper book has come. Then we can point it out, lot will take a call on.
how are you going to do that?
Yes. But with regard to the IA. With regard to IA, your lord,
Yeah.
for bail and suspension of sentence. If your lordship thinks that the whole matter should be heard together, that can. Don't have, but if
We-
your lordship
no.
rejects it
Ah.
at this stage, your lordship reject that at this stage, then if in some other, when the matter may not be heard for some time, then I'll also will not be able to pursue that. That is why I'm thinking. If somehow it is not heard,
It is a 23 matter. No, you've got you've got to wait in the queue also. This appeal has been filed this year.
about 3 years in jail already.
Huh?
Is in jail already for 3 years. About
Maybe.
3 years.
Well, this is a very serious offense.
Offenses.
you-
look to be
you-
serious.
Especially in the Northeast now, and especially with this trouble in the neighboring country, I'm telling you, the amount of drugs that are coming in
Yes.
to India, no joke.
Yes.
I remember in 2020, season in Mizoram, I know about Mizoram, was around 23 crores or 30. Last year it was 83 crores. And now to I think they're near about there. only.
Lordship, these are small fish.
Huh?
These are small. Fish. It's not 10,
what
20
to-
crores. It's about 20,000 crores in Gujarat.
But what to do? Every little bit counts. It's like this
20,000 crores, your
Englishman, this
lordship has
joke
got
I'll
in
keep on
Gujarat, nothing
saying.
happened. These things, your lordship, it's very difficult.
It's like this joke. Englishman is going to be hanged, and he says sarcastically to the hangman, "Oh, but I have got only one head to give to my country." And the hangman says, "Every little bit counts." Something like that. Where the
I
effect
understand.
is
I understand that.
Effect is huge.
effect is huge. And if you see actually these addicts, they, I mean, the poor, at least the poor segment, they all turn to stealing things and theft, everything. Effects are huge there. You feel sorry for the parents.
Huh?
Their houses, all the things are being
Yes.
taken away from their houses.
Because they
Socially,
have
it's a
to
big
have it.
evil. It's a big evil social.
Anyway, leaving
There's a
that
lot
aside,
have to
Big,
come and
leaving
my
that aside,
party.
this is
What
this
else
is
can
a commercial quantity.
That is,
I can understand if it's not a commercial quantity, we could have maybe, looked into it. Commercial quantity, there's no escape.
in fact, they have also not filed the objection. I think.
No, the written objection is not required. Only required when there is a chance of giving bail.
But it then may fix the whole matter after paper book.
No, we'll let them make the paperwork. I can hear you on the IA. That is no problem. On the basis of whatever. But there's nothing.
If your lordship thinks that way,
Yeah,
I'll leave it to your lordship.
okay.
He doesn't want to.
Because
dismiss the
otherwise, your
order.
lordship, Why should I ask you? Your lordship has already given me your mind. So I have
Ah.
already stated.
No,
your lordship has-
I've given you my mind because you see,
I
the,
also
we have,
understand.
we have gone through part
Yes,
of it.
that's why I understand.
That's why we are ready to hear you and we are ready to give,
Sometimes
yes,
it's not
ask you
necessary.
questions on that aspect.
Sometimes, your lordship, I have to understand more.
Yes, no. Okay, right. Heard Mr. Y.S. Manan, learned counsel for the applicant. Also heard Miss Who. I can give anyone's name, your name also.
On principle, I don't want to do NDPS matters, maybe I.
You will have to do it one stage or the other.
Hmm.
It is not as difficult as you think it is. Okay, heard Miss
Even
Jahan.
I have started, please, I have never been in this type of criminal practice. What has happened in 2020? when
Yeah.
Corona came, I was out of work.
Uh-huh.
So I started my practice was now
Okay,
a few
okay.
criminal cases I'm doing.
Everyone has a right to be defended. That cannot be taken away.
This is what is happening.
Yes.
For 1 month, I was sitting at home without any case. Only the matters, bail matters and criminal matters are there. One of my friends told me, why don't you do some criminal matters? I said, yes, it's the best side. At least I can earn some. So I started. So she can also do that.
You are
Now,
lucky, you all have got number of cases. I say, we have got to do every type of thing. You've got to be a jack of all trades because otherwise you can't survive.
yes, that is,
I started with what? Bail, liquor cases.
But then there are states where people, it specializes in few particular sections of the particular act. Like in Bombay,
Uh-huh.
there are advocates who does only
yes.
376.
But then there
Check.
might be a quantity, no?
Yes,
The
yes.
cases.
The
So
number
many
of
cases.
are so high there.
Ah,
Here it's,
here we
here
are
it's not-
not choosers.
it's the basic
Okay.
survival is there.
Yeah,
Here.
yeah, here we are playing survivor,
Ah,
survival.
We are not choosers.
And I'm finding it very interesting.
Huh?
Obviously, I'm finding this criminal side very interesting. We-
There are small nuances here and there, which I'm still learning from everyone here. I'm learning a lot. And, but NDNPS commercial quantity is very different.
I've got some bail also in commercial quantities. In some
Okay,
cases, yes.
That means they were,
I have got some.
okay, very good.
Even ABs are allowed and told.
You see,
it
it is
Not all the cases.
you have got some scope of maneuvering prior to the trial being concluded. In this case, there's already a finding by a court. Now to overturn that finding in a bail would amount to deciding the entire appeal.
I'm not saying about.
No, I'm just telling you.
In
So
fact,
it's
the
very difficult.
statute provided that no suspension of sentence should be allowed. But then Supreme Court allowed.
Law is dynamic, your lord.
Law is dynamic. We cannot stop from getting, this is also correct.
Irretrievable breakdown of marriage was never considered to come within the meaning of the word cruelty. That's not.
Now it is your lordship constitution that the Honorable Supreme Court.
Huh?
Delivery lordship on the making deliberation on the same section.
But one thing you see, one thing is that there has to be a development in law. The law cannot remain static. With
Justice
society,
Chandrachud,
with
therefore,
societal change, everything changes here and there. And someone has to take the lead.
The Honorable
Yeah.
Chief Justice rightly said, if we allow other things, so why not marriage? No, right there.
Okay,
In
right.
this case itself, your lord, the other two persons have been,
Acquitted.
There
On
were three
technical
persons.
grounds, perhaps.
in fact, one of the, this one bail was rejected earlier. The other one also, I think I have moved the bail that was rejected, but ultimately he was acquitted.
Okay, right. As Jahan learned, additional people. This application under section 389 is for suspension of the sentence passed by the Court of the Additional Section Judge number 2, Nagaon, in its judgment dated 17/12/2022 in special NDPS case number 17/2021. In the said judgment, in the said impugned judgment, the applicant has been convicted under section 18C, 20B2C and 21C of the NDNPS. You look at page 58. The learned counsel for the applicant submits that there was non-compliance of section 42 and 57 of the NDNPS Act. During the time of search and seizure. Search and seizure. And as there has been violation of the mandatory provisions of law, the learned trial court could not have convicted the applicant. Consequently, bail has to be given as the entire prosecution and as the entire proceedings before the learned trial court was vitiated. Further, there is nothing to connect the applicant with the contraband allegedly recovered by the police, correct? Police. Come in as much as the seizure witnesses have not stated in their evidence that they had witnessed the search, recovery and seizure of the contraband drugs. This aspect of the matter not having been gone into by the learned trial court, the learned trial court could not have made any findings with regard to the finding of guilt against the applicant. He accordingly submits that as the proceedings before the trial court was vitiated on account of violation of the mandatory provisions of law and the fact that there was nothing to prove that the applicant was in possession of the contraband drugs, the sentence should be suspended and the applicant should be released on bail. Next panel. Miss L. Jahan, additional PP, comma. On the other hand, comma, submits that the learned trial court having come to a finding that the applicant was guilty of the offenses against which charges had been framed against him, comma. It would not be proper for this court to suspend the sentence and release him on bail, comma, particularly when the contraband goods were of commercial quantity. She also submits that in terms of section 54 of the NDNPS Act, there is a presumption of possession of the illicit article on the part of the accused applicant. So, she accordingly prays that the application should be rejected. Next, on considering the submissions made by the counsel for the parties, we find that the applicant has been convicted on account of a recovery and seizure of commercial quantity of contraband drugs. The applicant has also been found guilty and convicted under section 18C, 20B2C and section 21C. As the issue whether there are reasonable grounds for believing that the applicant is not guilty of the offense would require going into the detailed merits of the case and now which would in effect now which and in which case, comma, the judgment of the learned trial court would have to be altered to enable the applicant to be released on bail, comma. We are of the view that on consideration of the materials before us, comma, no ground, the applicant cannot be released on bail at this stage. The application is accordingly rejected. Then in the main case, you write, as LCR has arrived, the registry to make the paper book list the matter after 4 weeks.
Much of.
Service awaited.
Can't hear you.
Service awaited.
Service away. Okay, right. Office note indicates that notice was issued to the respondent number 2 on 8/6/23. However, there is no return of AD card or unserved notice as on date. As such, await service report, list the matter after the vacation. The 30 days have not elapsed. Okay.
Kamar told me last night that he is, cannot do it today.
Oh, that matter.
Not
Ah, yes.
On Friday, it was done to,
There was nothing much for him to say. I mean, besides, there's nothing much to add. He was only supposed to bring some judgment. I think. Maybe he said he'll take 1 hour only.
Oh, he's not available today, your lord.
Huh?
He's not available today, your lord.
Why?
So, wait for time.
He's not able to today.
Available.
To do what
For court,
today?
your lord.
Huh?
He's not available for court, your lord.
it's not available.
He's not available.
Okay.
Why?
He's going some cases in special.
In the district court.
Right.
Oh,
Special
okay.
court, Assam.
Special court.
Special court.
Special court. So in a hierarchy of importance, where are we? Below the special court.
But suddenly.
Suddenly.
he's busy. Yes.
And this is a part-heard matter, So in a hierarchy, importance hierarchy, where do we stand? Supreme Court, Special Court, and High Court.
High court here.
High Court comes below Special Court.
Not, your
Or
lord.
comes below CJM. Where does it?
After this, apex court, high court comes, your lord, sir.
And then we have heard part of it, Mr. Counsel. And this is the day that you wanted it to continue. And we have made notes. 6 pages notes we have made. We heard you for, I think, at least 2 hours minimum on the last day. I can understand if you had not started the case at all. You had started the case, you did not complete your argument. So you wanted another date. We gave you the date. And date fixed by you. And then suddenly you say that you've got a case before the special court. Huh? This is not expected.
I would try at two, your lord.
Huh?
I would try at.
Or Monday. Tomorrow. I've seen there are contradictions, it seems there are, but then perhaps Lordship has taken the one step.
I don't know. There were basically he's trying to go on that contradiction, small contradictions here and there. That's all.
Yeah.
I mean, that is his basic case. That there are small inconsistencies, there are contradictions. So that is all. Anyway, what to do? He's not here. Why don't you carry on?
Try at two.
Huh?
I would try at two. Any other date?
Come, I doubt. Repeat partner.
Mr. Tiwari is waiting for this matter. There
Huh?
will be one hearing done.
No, maybe what, maybe, is it is it that, you were apprehensive that you might not get a favorable order or something that you have suddenly, not decided to come?
I think not so, Your Honor.
Not so. Because I don't understand. In the middle of a case, where the argument has not been completed, you suddenly decide that the special court is more important than the division bench of this court. Maybe now they want to avoid this court.
No, cannot be either.
I don't know. They're guessing because this is a ongoing matter. It's not a new. It's not a matter where the hearing had not started.
Monday. Monday.
Now they're not. They can't give dates also.
He perhaps has to again ask the commander.
Okay, right. Mr.
RSM.
R. Islam, Learned Counsel, appearing on behalf of the appellant, submits that his senior, Mr. Z. Kamal, has gone to the special court. Which special court? NDNPS.
Special Court Assam.
Huh?
Special Court Assam.
The special court. Why is it? Is the speaker not working or something? Yes.
It's Special Court Assam, Your Honor.
Assam?
It's Special Court Assam.
I hear that.
Special Judge Assam.
Special court?
Special Judge Assam.
Special Judge Assam. And as such, he would like to adjourn the matter. Mr. Ms. L. Jahan, additional PP, and Mr. Ayu Chaudhary. Correct. Number 2. Appear for the respondent. We had heard Mr. Z. Kamal for around 2 hours on the last day, that is 16/6/2023. And the matter had been fixed for today on the prayer of the counsels for the parties. For no, first of all. However, as the senior counsel for the appellants has gone to the special court. List this matter after the vacation.
It may be changed.
Huh?
17 meter.
17. Why do- List this matter on 17 is Monday straight away.
No, he's saying 2017 matters.
Okay, okay. When do you want? Give a date.
Immediately after vacation.
You want a date or we say after vacation?
Also that part.
They're trying to avoid probably, so why should we, will we allow them to avoid us if they're not List the matter on
On 19th.
19th.
Lordship can, if
Huh?
Partha, appear from-
We can put it as part of, but I don't know, but the bench might want, they might, the chief might want to change it also, we don't. Not, it was not kept as partner on the last day.
that's
So
not
now
okay.
to put it as partner in his absence might not be. This is a matter of 19. We thought we'll finish it today, unfortunately.
Sorry.
We had made some notes also.
Huh.
I'd given dictation, I think. I've got it in my desk. Oh, I did it when I went inside.
It's a wastage of time.
Huh?
Pure wastage of time.
Now we'll forget. Anyway, but at least next.
My lord, I'm appearing as an amicus in this.
Huh?
As an amicus, I'm appearing.
Am I case okay? What is the case?
My lord, basically the case is that the accused appellant herein has been shown as an living partner of the deceased man. They were in a
You're the
living
living, shown as a, so
living-
you're the living partner according to you, you're not.
Yes, ma'am.
Living partner.
Yes.
Some witnesses say they were husband and wife. Some say they used to live together and there was nobody else.
So who died? The partner died.
The
Yes,
partner died, the husband died.
husband
my lord.
died.
Husband died.
Yes.
Husband died.
Oh, that's
Now,
not
my
the. So you're for the woman.
Yes, I am for the moment, appellant. Now, my lord, on 3 counts, my lord, the judgment has been passed, my lord. First, taking the circumstantial evidence. First part, my lord. The second.
Yes, you see, we cannot hear you actually. I was thinking is something wrong with my ear. I was thinking. Another thing, Rakesh, I think you should take out these windows, these glasses. We took it.
No, your lordship, this side also, other side's voice is not coming up properly,
Not coming.
not properly.
Mic is not working. No, like that is working, but when you speak, it's not
Yes, my lord,
working.
correct, correct.
Raise the volume. Yes,
Now, my lord. 3 counts, my lord, the judgment has been passed, my lord. First is the circumstantial evidence, my lord.
this is a 302 case.
Correct, my lord.
I think my voice is quite loud,
Yes, my lord.
Lordship.
but
Yes,
we have put it at maximum,
yes, my lord.
but yours is just about
Voice is-
audible.
So, my lord, first is circumstantial evidence, second is, my lord, last seen theory, and third one is, my lord, no reasonable explanation under 106 of the Evidence Act, my lord,
No reasonable explanation.
under 106. Being a living partner, my lord, I was required to give a reasonable explanation about my absence from the place of occurrence on the fateful night, my lord. These are the things. Now, my lord, will kindly come to, my lord, I'll place cogent evidence in the record which says that I was not there on the fateful night. That apart, the time of the death and the report of the postmortem is taken up, my lord. My lord will find there is a huge
Between what? Between the,
my lord, they say that the incident occurred at night, my lord. But as far as the postmortem report says that the time of death is 12 to 18 hours, which again is 10 hours less from the time.
10 hours less from which time?
The
Greenwich Mean Time, what time?
My lord, they say that the incident.
What is the time that you are supposed
time
to
has
have
not
done
been-
that?
Time has not been
Mentioned.
stated, mentioned here, my lord.
Huh?
In the PM report time, since the column is not there, I did not find it, your lordship.
My lord,
I was looking for time since that it has to be mentioned in the postmortem report, but I did not find it in the postmortem report,
It is not
time
there.
since date column. In some of the reports, doctors mention, the report mentions, my lord, time since death, but here nothing is there.
May I start with the FIR, my lord?
This is,
FIR is at page 4. my lord.
Gentleman with white attire is at the back, are at the.
oh, there at the back, yeah. 2 minutes, okay. Yes,
Humble submission is that at around 1 p.m. on 9/8/18, I saw my uncle, namely Haradan Karmakar, residence of so and so, lying dead inside his residence. It is known to me as well as to all the villagers that one woman, namely Regina Karmakar, used to live with my uncle, but no marriage was solemnized between them as per social customs. I have come to know that they often used to quarrel with each other. That last night also a quarrel took place between them, and that thereafter Regina Karmakar left the house and stayed in the house of some other person. So my lord, this is important. The informant himself says that she left after the quarrel. The said woman did not give us any information about the death of my uncle, seeing injury on the head and some other parts of the
no,
dead body.
we do not know if she left the house before or after the incident.
My lord, that what I'll place the argument at the later stage, my lord.
So what I'm saying is that this fact does not prove anything.
Yes, my
It's
lord. that
neither
is
here
correct.
nor there.
My lord, that is why, my lord, I'll try to show my reasonable explanation under 106, my lord. This is what I'm trying to place before this court, my lord. Seeing injury on the head and some other parts of the dead body of my uncle, it appears that the said woman had killed my uncle. Now, my lord, the case was registered under 302, my lord. Now, at page 6, your lordship would find the charges were framed under 302, my lord.
Yes.
Now, my lord, PW1 is at page 8, my lord.
Yes,
The doctor who conducted the postmortem, my lord.
when was the charge framed?
The charge was framed on, my lord.
2019.
Yes, my lord.
Okay, then.
Now, my lord, you see at page 8, the PW1, the doctor who conducted the postmortem, my lord. The injuries are here, my lord. On
which page?
page 8, my lord.
Page 8.
PW1, the
Yes.
doctor who conducted the postmortem, my lord. On 10/8/2018, I was working as an associate professor, HOD in charge, Assam Medical College and Hospital, Dibrugarh. On that day, I have performed postmortem examination on the disease Haradan Karmakar, male in reference to Moran Police Station case number so-and-so, escorted and identified by Constable so-and-so, relative of the disease, and found the following injuries. External appearance: one average male dead body wearing one jeans pant, full shirt, eyes closed, mouth closed, rigor mortis present all over the body, postmortem staining present on the back, abrasion of 1 cm into 1 cm so-and-so. My lord, these are the injuries, my lord. Now, my lord would kindly come to direct to the opinion part, my lord, because from this only 10, 12, 15 and 17 were through a sharp weapon, my lord, and rest were through a
Okay, please read the opinion.
that is due to coma as a result of head injury sustained as described. All injuries are antemortem and caused by blunt force impact except injury 10, 12, 15 and 17, which are caused by sharp cutting pointed weapon. Injury 17 sufficient to cause death in ordinary course of nature. Homicide in nature and times in death 12 to 18 hours, my lord. This is important. 12 to 18 hours.
Well, madam? What? Now, what is happening to your microphone?
Lordship, times is date factor. I don't know, I did not find it, I may be wrong, my lord. On perusal of the postmortem report, that column is not there. On what basis the doctor has opined, my lord, our witness? Homicidal nature, times is date.
We can see the records. You see the record. See the record.
Now, my lord, PW2 is the informant, my lord. At page 10, my lord. May I read, my lord?
Yes. AC. It's put on the AC. It's printed.
I am the informant of this case. I know the accused person. The deceased Haradan Karmakar was my uncle. About 4 months back, VDP secretary of our village, Rupal Kumar, informed me that my uncle Haradan Karmakar was expired. After receiving the information, I went to the house of my uncle and saw a gathering in his residence. The dead body of my uncle, lying inside the house. The Regina Karmakar and my uncle were living in together relationship, and both of them resided in this house of my uncle. I came to know from the villager that both of them quarreled regularly. Later on, I lodged one FIR in connection with the case. None except the accused and deceased resided in the said house. Exhibit 1 is the FIR. Exhibit 1 is my signature. Police took my statement in connection with the case. Police took my signature in the inquest at Assam Medical College and Hospital, Dibrugarh. Exhibit 4 is the inquest. Exhibit 4 is my signature. Now, my lord, cross part. I attend my duty regularly. I stay in a different line, and therefore I cannot say whether any conflict had taken place between the accused and the deceased on the fateful date. I do not know about the contents of the FIR. I do not know how to read and write properly. I put my signature on the ADR as per direction of villager. I do not know why I lodged it. So this version is in the cross part, my lord. Now, my lord, PW3, page 11, my lord.
Anyway,
For
this,
hearing this
this,
case, no eyewitness is there. my lord.
Mr. Counsel,
Yes, my lord.
in any event, the cross-examination, how is it so important? Because in his examination in chief also, he doesn't say anything.
Yes, my lord. That is correct, my lord.
Then
Now, my lord, PW3, my lord, page 11, my lord. Because here in this case, no eyewitness is there, my lord. I know the accused Regina Karmakar as she resided near my house. I know the complainant also. He too resides in the area where I reside. The deceased Haradan Karmakar was the husband of the accused Regina. On the fateful night, I heard noise of quarrel that took place between Regina and her husband. They often involved in such quarrel. So we did not put much interest to it. On the next morning, Regina informed all the neighbors that her husband did not get up from bed and he bore an injury mark on his forehead. So now, my lord, here it comes that Regina informed all the villagers, the appellant, my lord. Along with the other neighbors, I too visited the residence of Regina and found her husband lying on the bed and having an injury mark on his forehead. I also noticed that the floor of the house was besmeared. So, my lord, this part was also taken in the judgment, my lord. Sticky part, my lord, present in the floor. Subsequently, the VDP informed police about the incident. Police appeared accordingly. In the residence of the deceased, only 2 persons, namely Regina and her husband, resided. Now, cross part, my lord. I was a worker of Sipon Tea State. At the time of incident, I already took voluntary retirement. I know Mohesh Karmakar. I do not know if any incident of assault had taken place between Regina and Mohesh Karmakar. I do not know what was the relationship between them. I do not know what was the cause of quarrel between the accused and deceased. I do not know who committed the murder of deceased Haradan Karmakar, my lord. Now, my lord, PW4 at page 12, my lord. I know the complainant as well as the accused as they are my relatives. Late Haradan Karmakar was my elder brother. About 7 months before Haradan died, from one Meghnath, I came to know that my brother Haradan expired. Now, my lord, this Meghnath, my lord, I'll just come up later, my lord, about this person. Immediately, I went to the residence of my brother and found his dead body lying on bed. I do not know how he expired, but I know that quarrel often took place between him and his wife. At the time of incident, my brother stayed in the residence along with his wife. There was no other person except them residing in the said house. During investigation, police examined me. The cross was declined, my lord. Now page 13 is PW5, my lord. I know the complainant and the accused person as they are my neighbors. I know the deceased Haradan Karmakar also. The incident occurred about 1 year back. In the last year, one morning, I came to know Haradan Karmakar was murdered. I noticed a gathering in the house of Haradan Karmakar. Dead body of Haradan Karmakar was lying in his bedroom. The accused is the wife of the deceased Haradan Karmakar. The quarrel often took place between them. I also come to know that the accused committed murder of her husband. At the time of occurrence, there is no other family members. Only the accused and the deceased were present there. Usually the deceased and the accused persons only stayed in that home. Police recorded my statement in connection with the case. I do not know who were present in the residence, cross part manner. I do not know who were present in the residence of the accused at the fateful night. I do not know what happened on that night. On the next morning only I came to know about the alleged incident. So, my lord, now the last witness, my lord, page 14, the IO, my lord. Page 14, my lord.
Yes.
On 9/8/2018, I was working as an OC. On that day, Sri Sujit Karmakar of so-and-so line lodged an FIR at the PS alleging that Srimati Regina Karmakar committed murder of her parental uncle Haradan Karmakar. After receiving the FIR, I registered a case while Moran PS number so-and-so, and I took up the investigation of this case. I recorded the statement of the complainant at the PS. I, along with the complainant and staff, proceeded toward the place of occurrence. The place of occurrence was the staff quarter of so-and-so tea state, allotted in the name of Haradan Karmakar and situated at Sipon Botani line. When I appeared in the place of occurrence, I found the dead body was kept in the floor of a room, surrounded by clothes, and also noticed that the floor of the house was besmeared. I have also noticed a wound on the head of the deceased. I drew sketch map of the PO. I informed the circle officer, but she was not able to present at the PO, so I made the inquest over the dead body. I recorded the statement of 6 witnesses who were residing near the house of the accused. After
If he recorded 6 witnesses, how
there are
many?
only 5, my lord.
Huh?
There are only 5. 6th is the person only, the IO himself. So one of the witnesses missed out, or neither he turned up in the court. That can be the other
Okay,
part,
next.
my lord. I recorded a statement of 6 witnesses who were residing near the house of the accused. After recording the statement of the witnesses, I came to know that the accused lived with the deceased person at the place of occurrence in living together relationship. During my investigation, I found that the accused and the victim only stayed in that house. During my investigation, I came to know that on previous night, a quarrel had taken place between the accused and the victim. After the quarrel, the accused went away from the house, and on the next day she returned. So, my lord, this part has also come from the IO. On the night, she left, and on the next day she returned, my lord. Well, I'll place why I'm pointing out this point only, my lord. During day's hour at about 1 p.m., at 1 p.m., she informed the neighbors about the death of the disease. When people gathered on the spot, they found the victim dead. Therefore, we suspected the accused for committing the murder and picked her up and brought to the police station. After interrogating the accused person, I found sufficient materials against her. Accordingly, I arrested her and forwarded it to the court. I collected the PM report, from which I came to know that injury sustained by the deceased was antemortem and homicidal in nature. Finding sufficient material against the accused person, I laid charge sheet against the accused under 302. Now, my lord, the exhibits are there, my lord. Now, the
Let us go to, yes.
cross part, my lord. The witness that I examined during investigation did not state where did the victim go after the quarrel that took place on the previous night. It is not a fact that when other suggestions were, my lord, denied, my lord. It is not a fact that accused person in no way connected with the alleged offense. It is not a fact that without any basis and merely based upon the FIR, I laid charge sheet against her. It is not a fact that no witness could prove the charge against the accused person. So, my lord, the evidence as far as collected by the IO speaks that on the previous night there was a quarrel. So even it is assumed, my lord, that on the fateful night, if I have killed the lady, my lord, killed the deceased, my lord, if this appellant has killed the deceased, my lord, in that case, my lord, I'll directly take your lordship to the postmortem report, my lord. which is at page 42, and the relevant part is at page 47, my lord. It starts from page 42, but the relevant part is at page 47. Now, 42 for a moment, your lordship would find page 43. Page 43 is the, my lord, date and hour of dispatch of the dead body from the police station, my lord. Page 43, my lord, first line, my lord.
Yes,
Dispatch, my lord, 10/8 at 10:30 AM. Then my lord, arrival at the dead house is 1:30 PM, my lord. Examination done at 2 PM on 10, my lord. And my lord, the time of death has been shown as 12 to 18 hours. And if the FIR is taken note of, then my lord, the person has expired on 8/8/18,
just a minute.
my lord.
So this is the post-mortem report.
Yes, my lord.
PMR made on which date?
On 10/8/2018, my lord.
10/8/18.
Yes, my lord.
And 10/8/18 at what time? 1 to 2 PM.
At 2 PM, my lord. 2 PM, my lord. Now, my lord would find at page 47, the opinion part, my lord.
Just a minute. And the FIR filed on
FIR filed on, my lord, 9/8. On 9/8, my lord,
9/8.
at 1 PM. First line, my lord. Now, my lord, take.
So according to you, since it was 10/8/18, so he could have been killed only at
On-
what time?
On 9/8 at around 1 PM only.
And
It has to be 1 PM then, my lord.
Information received in the police station on 9/8/4 PM. Page 1, the chart, my lord.
chart per chart.
Chart, the column is there, on chart of the FIR.
Chart FIR is at, my lord, this is at page. Page 1, my lord.
Serial number 3.
Page 1 also, my lord, can see.
So what do you mean? You mean to say that he was still alive? He could not have died. He must have been alive. Huh? That is the case.
My lord, what I am.
Yeah, minor discrepancy.
No, my lord, what I'll place before your lordship is this. Now, my lord, page 47, lordship
Because,
will find the opinion.
because of the post-mortem report, he must be walking around. He could not have been dead. That's what you're trying to say.
No, my lord. My lord,
Or that the dead body.
the examining doctor, my lord, speaks about 12 to 18 hours, the probable time, my lord. But if we take that the lady was there with the person, my lord, then the person would have died on 8/8, my lord, by 10:30, 11, 12.
So there was some mistake. Then
That is what-
unless you could have seen a walking dead person, that's a different issue.
But my lord, here he says the VDP. Now, my lord, after this, I'll take your lordship to the 313 statement, my lord, where, my lord, the lady has given a reasonable, plausible answer to the questions of the court, my lord. Because here in this case, my lord,
Let us see 313. That's why I
Yes,
said,
madam.
let us see 313.
my lord would come, my lord, page 16, my lord.
Page 16.
Yes, my lord.
Answer to question.
Because
number
she has answered all the questions, my lord. Page 16, my lord. Because twice the 313 were taken, because initially the trial court skipped out PW1, the post-mortem doctor, my lord. So, my lord, the 313 was taken twice in this case, my lord. So, may I read page 16, my lord? The first question was put on. The PW2 Sujit Kumar deposed in his evidence that on the fateful day, his uncle was found dead in the residence, where you along with the deceased resided. The witness also stated that during your stay in the said house, both of you quarreled regularly. But what do you say in this regard? It is incorrect that there was a quarrel between us on the previous night. My husband Haradan, being drunk, drove me out of the residence, for which I took shelter in the residence of Mohesh Bauri. I do not know, therefore, how that occurred to him. On the next morning, when I went to my home, I found my husband in injured state. Now, she says that injured state. This is what I'm trying to place before the lordship, that thereafter only she went to the VDP secretary to inform that her husband was found injured. Now, I'll show my lord from other part. At that time, he was unable to speak anything. he was under influence of alcohol. Then I called the villagers. The first explanation, my lord. Now question number 2, my lord. The PW3 Somu Nayak stated in his evidence that you often had quarrel with your husband. On the day of incident, he found your husband dead in your residence and noticed that the floor of the house was besmeared. What do you say in this regard? I do not know how my husband died, as I was not present in the residence at that time. I also found the floor of the room was besmeared when I came to the residence on the next morning. So here also she did not lie, my lord. What she found and what the PW3 found, my lord, and the IO found, well, she has also corroborated that part. Now, question number 3. PW5 Sankar Nayak stated in his evidence that on the fateful day he came to know that you had committed the murder of her husband. What do you say in this regard? No, I have not committed any such act. At the time of the incident, I was not present. Question 4, my lord. From the evidence of PW6, it appears that the police investigated into the matter, and on the closure of the investigation, police found materials against you and submitted charge sheet. What do you say in this regard? Police has not investigated the matter properly. Now, question 5 is most important, my lord. Do you
Yes.
want to say anything? Now she gives a plausible explanation. I am innocent. I have not committed murder of my husband as alleged. On the previous night, the accused had a large amount of alcohol. I advised him not to have alcohol. Then he rebuffed me and went out. After a few minutes, he again came with 2 bottles of country liquor. I told him to have dinner instead of liquor. At that point, he caught hold my neck and gave a push. He drove me out of the residence, for which I had to take shelter of my residence of Mohesh Bauri. On the next morning, when I reached home, my husband was lying on the ground. I noticed injury mark on his forehead as well as shoulder. As he was sweating, then my lord, some part is missing, with a cloth and went out to call villager. I found Meghnad Rajput on the way and asked him to wait for some time beside my husband and went to call the president. When I returned back, I found my husband dead. So by the time she reached the house, my lord, she says that her husband was alive. And that corroborates with the postmortem, my lord, 12 to 18 hours. Because the doctor has rightly stated in this case that the death occurred 12 to 18 hours. So, my lord, at the night, she was not
just
there. When she returned, my lord, she found her in.
just
that
a
is what-
just a minute.
Yes, my lord.
The postmortem was done at 2 p.m.
Correct, my lord.
So 18 hours prior to 2 p.m. of 10:18 will be how much?
My lord, it would be around.
You see, on 10:18, 2 p.m. means 14 hours gone.
Yes, my lord.
Another 4 hours, if you add, that will be 8 p.m. of 9/8.
Yes, my lord.
Correct. If it's 9 p.m. of 9/8, when was the FIR given?
FIR was on 9/8, my lord.
Yes, which time?
At 4, my lord. 4
4.
p.m.
That time though he was at 4. Now, according to that calculation of the doctor, he's supposed to be still alive. He's supposed to be alive at 4.
No, my lord.
10 to 18 hours.
My lord.
Please go back in time. This is simple mathematics. You see, that is what I'm trying to say. That you cannot go simply by the maths that has been put up by the doctor. 18 hours, if you calculate from 2 p.m. of 10/8. 10/8, how many hours are there have used up by 2 p.m.? 14 hours. So 14 hours. Now that means out of 9 on 9/8/2018, there are 24 hours. You cut away 4 hours because 4 hours are left. It comes to 20 hours. Now 20 hours on 9/8 would be what time? It would be 8 p.m. at night. And the FIR was filed at 4 p.m. So according to you, according to your calculation, at 4 p.m., this disease should still be alive.
No, my lord. I'm not on that, my lord. What I'm on is that, my lord.
You can say that it was close. Don't say that it proves. Because it does, the maths do not they do not come out as the way you have calculated it.
My lord, I am calculating on the other way around, my lord. I am calculating that if at one, the VDP secretary informed the nephew of the deceased that your uncle has expired, then from 1 PM of 9 to 1 PM of 10, my lord, would be 24 hours, my lord.
Correct.
And then, my lord, adding 1 more hour, my lord, it would be 25 hours, my lord. So probably if we go by the doctor's calculation, my lord, 12 to 18 hours, then it is presumed that the person has died only on 10th, only on 9th, my lord, not on 8th, my lord.
Correct.
Not
but-
on the previous
but
night,
Not
my
on the time that you mentioned. Not on the time you mentioned. Postmortem was done at 2.
Yes, my lord.
Then, anyway, those are small issues. So you are trying to make it, 2 plus 2 is equal to 4. It is not. The doctor's postmortem report, when you go strictly by the time, you cannot go strictly by the time. That's what I'm trying to tell you. If you go strictly by the time, then at the time the FIR was submitted, he should be still walking around, maybe drinking still or something, or lying there in the. That it doesn't add up. That's what I'm trying to say. Anyway, let us not
Okay, my lord.
worry about that issue.
And as far as this PW1, the second 313 was taken, my lord, so she had only answered that "Yeah, I have not killed," because the
Why
doctor-
was the second 313 taken?
because, my lord, in the first 313, my lord, PW1 was skipped by the learned trial court, my lord.
Okay, the evidence given by PW1.
The postmortem doctor, my lord, that was skipped in the,
So those questions that.
these questions were put in the second 313. my lord.
Okay, then. So
Then-
what else?
So, my lord, basically, the case,
Now there is no weapon seized.
no weapon seized.
Where is the trial court judgment? What is the basis for conviction?
The basis for conviction was, my lord, since all the witnesses have said that they were the only persons who were living in
Living
the
there.
said house, my lord. So, my lord, that 106 presumption was taken, my lord. And last in theory, since yesterday night, PW3 heard that there was a quarrel in the house, my lord. So the trial court believed in that version and convicted the person on the basis of circumstantial evidence, last in theory, and
Let us
106.
see what the learned trial court
Yes,
has said.
Yes, my lord.
Please 35.
Page
Page
20 is the, my lord, judgment starts from page 20, my lord.
But which is the relevant portion?
Yes, my lord. The relevant portion, my lord, it starts from
Para 33.
page 9, my lord. Page 23, my lord, para 9, my lord. The discussions are here, my lord. Thereafter, my lord. Okay, my lord, then, my lord, I'll take your lordship to the,
Para 33 on.
my lord, para 23, my lord, would see for a moment, my lord.
No. We go to para
33,
33.
your lordship, please 34.
From para 32, I think.
Yes. Circumstances.
Page 33, para 32.
Yes, my lord. May I read, my lord?
Yes.
Thus, in view of the above discussion, the prosecution has succeeded in proving the following pieces of circumstantial evidence in this case beyond reasonable doubt, my lord. That on the following day of the night of occurrence, the dead body of Haradan Kamaka was found inside the house. That there were multiple injuries on the on the body of the deceased, including the fatal head injury. That as per the post-mortem examination report, the injuries were anti-mortem and homicidal in nature. That the floor of the house was found besmeared. I have already highlighted the significance of this piece of circumstance in the paragraph 23 of the statement. That only the deceased and the accused used to reside together in their house as husband and wife. That on the intervening night of 8/8/2018 and 9/8/2018, also the accused was found present in the house with the deceased. That quarrels often used to take place between the accused and the deceased. That on the intervening night of 8/8/2018 and 9/8/2018, also there was a quarrel between the deceased and the accused. And one of their immediate neighbors, PW3, has heard the noise of their quarrel, and that the accused has failed to discharge her burden under section 106 of the Evidence Act in the offering her explanation regarding the circumstances leading to the death of the deceased. From the above circumstances proved by the prosecution, the conclusion of guilt of the accused is fully established. All the above circumstances are of a conclusive nature and tendency and consistent only with the hypothesis, the guilt of the accused. The above circumstances from a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and show that in all human probability, the offense in question must have been done by the accused and none else. So far as the question of motive is concerned, it has surfaced in the prosecution evidence that quarrel often used to take place between the accused and the deceased, and on that fateful night also there was a quarrel between the two. The accused strained relationship with the deceased might have led her to take the ultimate step of causing his death. The said motive, however, appears to be obscure and not clear. It is true that a clear proof of motive from the crime lends additional support to the finding of the court that the accused was guilty. But the absence of a clear proof of motive does not necessarily lead to the contrary conclusion if the prosecution has otherwise convincingly proved the guilt of the accused, as in the instant case. So, my lord, thereafter, the judgment was referred, my lord. Now, para 35, my lord. My discussion would be incomplete if I leave a few other aspects undiscussed. There is admittedly no recovery seizure of weapon of the offense in this case. It appears that from the evidence of PW6IO of this case, that at the place of occurrence, he found the dead body of the deceased with a wound on the head, and he noticed that the floor of the house was besmeared. He has not stated anything about the presence of any incriminating article, including the weapon of the offense at the place of occurrence. This is, however, a mention in the charge sheet that during the inspection of the place of occurrence, no article connected involved with the case which is worth seizing could be found at the place of occurrence. No matter the weapon of the offense could not be recovered, seized in this case, the prosecution has nonetheless succeeded in proving the case beyond reasonable doubt on the strength of chain of circumstantial evidence, which is consistent only with the hypothesis of the guilt of the accused. The next aspect is that as per the opinion in the post-mortem examination report, the approximate time since death was 12 to 18 hours. The post-mortem examination was done on 10/8 at 2 p.m. If the time is stretched back to maximum, that is to 18 hours, the time of death as per post-mortem opinion would come at around 8 p.m. on 9/8/18. But in the present case, the occurrence was of the intervening night of 8 and 9. And as per the testimonies of the PWs, the victim Haradhan Karmakar was found dead in the house on the following day, that is on 9/8/2018. The accused has stated in a statement under section 313 of CRPC that on the next morning she found her husband lying on the ground and she noticed injury mark on his forehead and shoulder, and that she went out to call the villager, and when she returned back she found her husband dead. In view of this difference between the evidence of PWs and the medical evidence regarding the time of death, the evidence of PWs has to be relied on, and I do so. One more aspect is as regard the inquest on the dead body of the deceased, which was done on 9/8/18 at 4:30 p.m. It is in the evidence of PW6IO that he informed the circle officer, but she was unable to be present at the place of occurrence. So he himself made the inquest over the dead body. It, however, appears that the inquest was done in a perfunctory manner. In the inquest report, the IO did not even mention the description of injuries found on the dead body, but mentioned in the opinion portion as revealed by the witness is death due to injuries sustained caused by his wife Regina Karmakar. Be it mentioned here that the accused herself has stated in her examination under 313 of CRPC that she noticed injury mark on the forehead and the shoulder of her husband.
Okay, I think we've heard. So basically, the death occurred in the night of 8th to 9th. And keeping in view the doctor's report, that person could not have been dead at that time. That's what you're trying to say.
Yes. And my lord, it is the IO who in the evidence have stated that the lady left the house on the night. The informant also says that she was not there.
Anyway, so basically you're saying that she could not have done it. That's all.
She could not have done. And my lord, other way around, my lord, what I'll say is that even there are or else every day, no such previous incident of assault has come out anywhere in the evidence. That he earlier also she caused injuries. So those part are
There
not-
is always a first time.
Yes, my lord, that is correct, my lord. That is correct, my lord. There is always a first time, my lord. Now, my lord, would other way around, my lord would appreciate one part of the evidence, my lord. That 201 was never taken in this case. As the,
What is 201?
my lord, disappearing the evidences, my lord, 201. They say that the house was besmeared, my lord. While they reached, my lord.
What do you understand by the word besmeared?
My lord, the sticky portion on the floor, my lord,
Is
it
it?
says that the blood
See,
stains.
Where does it say that besmeared has to be? Does it say that it's besmeared with blood?
No, no, my lord.
Then
It-
how do you say that
No,
sticky
my
with
lord,
blood?
I'm not on that, my lord.
You are saying that, you're trying to imply that. Don't imply something which you're not clear about. The evidence only states that it was besmeared. It does not say that it was besmeared with blood. Could have been besmeared with earth, could have been besmeared with some dirt. So where does it say blood? Why are you thinking that it is blood straight away?
No, no, I'm not on that, my lord. What I'm on is that, my lord, it might be the case that, my lord, he was in a state of,
Huh?
my lord, he was in a state of intoxication, my lord.
So,
Might be this person has at the night come out, my lord, had an, my lord, fight with some other persons, my lord, he was.
maybe,
killed by-
maybe,
So,
maybe.
my lord, it is not a clear case that this appellant, my lord, has been the direct person, because, my lord, had the IO would have taken.
We
some
understand,
NDCF, my
that's
lord,
what you're trying to get at
some
that.
witness, my lord, some weapon could have been seized, my lord, some witness could have been
Okay,
recovered, my lord.
we understand, we have heard you on
So
that.
that part is not, that part is missing, madam.
Yeah. Any citations or anything?
And
About it?
citations, my lord, only on circumstantial evidence, last seen theory, my lord, some judgments of Supreme Court are there, my lord, I'll just place, my lord. Those says that, my lord, I'll just place, my lord, the first, the recent judgment of the Supreme Court, my lord, reported in. My lord. 2022 3 SCC criminal,
2022,
3 SCC 165, my lord. Para 22 and para 26, my lord.
okay, we'll see this after lunch.
May I read, my lord?
Yes,
It is true that the entire case of the prosecution rests on the circumstantial evidence, inasmuch as those certain facts were admitted by the appellant accused in his further statement under section 313 of CRPC, like his visit to the house of the victim on the previous evening of the alleged incident, and he having been arrested and brought back from Bhagalpur, Bihar, as per the transit remand granted by the concerned court. There was no eyewitness to the alleged incident. The law with regards to appreciation of evidence when the case of prosecution hinges on the circumstantial evidence is very well settled. The 5 golden principles laid down by this court in the case of Saraj Vidichan Sarda versus State of Maharashtra and followed in Katrina decision are worth reporting, my lord. A close analysis of this decision.
Yes, yes, we have got that, we have got
Following
that.
condition.
yes, we have got, then
Then, my lord, para, my lord. Then, my lord, I'll take your lordship to para 26.
26,
This, my lord, I'm arguing only for the last scene theory, my lord.
last in theory, okay.
Yes, my lord. Once the theory of last scene together was
So according to you, explanation given.
yeah, explanation given. Because, my lord,
Next.
apart from the explanation, my lord, my second submission would be, my lord, in the FIR itself, the informant states that after the quarrel I left, my lord. That is what, my lord, initially I saw that after that I left. And in my 313 also. I have
Informant says that.
yes, and in the 313 also, I have stated that when I
But
asked.
can that be an evidence? But can a statement
Yes.
made in an FIR be substantive evidence?
My lord, to my understanding, it would be, my lord.
How?
Because, my lord,
It's not, it's, how can it be, it'll just be a statement at most. It's not evidence, it's not
Because-
under oath.
because, my lord, the IO in the case also in his cross-examination states that the witnesses
Okay, the
who
IO,
I have interrogated have also stated that after the quarrel she left.
okay,
This is what has come
that
from
is,
the IO.
that is the IO's.
That is the IO also there, my lord.
So you take the IO's evidence,
Yes, my lord. I'm taking the evidence of the IO, my lord. He also says that.
because
he-
the FIR has got no value.
Yes, my lord. The second judgment which I'll place before your lordship is. It's a recent Supreme Court judgment, my lord. 2023, one crime SC 2110.
It's maybe on the basis of the FIR. Not the- so what is the value? But anyway, there is this aspect of not clear whether she was really there. There is nothing. Explain. Yes,
My lord, this second judgment which I placed before lordship, my lord, para 6, my lord. Again, my lord, last in theory. And my
Para-
lord,
that's a second.
para 6, my lord. Internal page 3, my lord.
Yes,
This is also under 106, my lord. Evidence like last in theory. My lord, I'd just like to read out this paragraph only, my lord 6. It may be noted that once the theory of last seen together was established by the prosecution, my lord, I say that it is not established by the prosecution, my lord. The accused was expected to offer some explanation as to when and under what circumstances he had parted the company of the deceased. So, my lord, the IO also says that she left after the quarrel. It is true that the burden of proof the guilt of the accused is always on the prosecution. However, in view of section 106 of the Evidence Act, when any fact is within the knowledge of any person, the burden of proving that fact is upon him. Of course, section 106 is certainly not intended to relieve the prosecution of its duty to prove the guilt of the accused. Nonetheless, it is also equally settled legal position that if the accused does not throw any light upon the facts which are proved to be within his special knowledge in view of section 106 of the Act, such failure on the part of the accused may be used against the accused. It may provide an additional link in the chain of circumstances required to be preconized. In the case based on circumstantial evidence, furnishing or non-furnishing of explanation by the accused would be a very crucial fact when the theory of last seen together as propounded by the prosecution was proved against it. But here in this case, my lord, that part was somehow missing, my lord. Now, my lord, the last judgment which I'll place before your lordship is reported in 2019 7 SCC 773, my lord. Para 14, my lord. Now, my lord, this judgment also speaks about the circumstantial evidence only, my lord, that every hypothesis should.
so you have already given one
Yes,
judgment,
one
what do you
judgment,
want this time?
So, my lord, this is what my humble submission, my lord, I'll sum up my argument with only 4 points, my lord. First part, my lord, the FIR. FIR, the person was an hearsay evidence.
Huh?
The FIR, the informant who has lost the FIR is also a hearsay witness, my lord, or otherwise say hearsay evidence. Now, my lord, he, after hearing from the people of the locality, has filed the FIR, because in the cross part he says that the villager asked me to lodge the FIR, so I have filed it. Meaning thereby that the villager also corroborated with the statement that the lady left after the quarrel, my lord. Because well, once again, I'll take your.
But who has said in evidence that the lady left after the quarrel? Where is the evidence?
No, my lord. What I am trying to place before your lordship, the cross statement, my lord, the cross examination in which the PW2, my lord, the informant says, I attended, my lord, the relevant part, I do not know the contents of the FIR. I do not know how to read and write. I put my signature on the as per the
So,
direction of the leaders.
so the question is, where is the proof that the lady had left?
My lord, this is what, my lord, I'm trying to place in my lord, in a different note, my lord, that the person was not present, the informant was never present. Now he files the FIR on the description what the villagers have said, my lord, meaning thereby the including the PWs also. PW3 also.
So that has got no meaning, according to you. When the evidence of the informant has got no meaning, then the FIR also has got no meaning.
Then, my lord, again I'll come to the IO then, my lord.
IO's evidence is based on what? He saw it or what?
No, my lord, on the interrogation of the witnesses, my lord.
Which witnesses?
This is what, my lord, the IO says, my lord, PW6 for a moment, my lord.
Correct, but which witness?
PW2,
Supposing IO says,
PW3, PW4,
Huh?
PW5, my lord.
but what does PW 3, 4, 5 say? Do they say that this lady had gone out of the house?
But, my lord, the
From where did
PW.
the IO get that information? He has to clarify.
Correct, my lord.
And then the maker of that evidence will have to also say something to that effect.
Then, my lord, I'll argue that there was a defective investigation on the part of the IO because
can
he did
argue
not try
that.
to.
Yeah,
Because, my
you
lord,
can argue that.
the doctor who conducted the postmortem, my lord, has said that injury 10, 12, 15 and 17 are through a sharp weapon, my lord. Rest are of blunt, but he could not recover any of the weapon. Neither he took up any such step in the entire prosecution case, my lord, that he even tried to recover the weapon, or he interrogated the accused appellant towards discovery of the weapons, but that was also not done. Meaning thereby, my lord, that that defective investigation, my lord, does not.
So we cannot really rely upon the evidence of the informant and the IO, as it's all hearsay.
Yes, my lord. But other way around also, my lord, none of the witnesses have said that I have killed my
So
lord.
if we cannot rely upon them, then similarly, the prosecution cannot rely upon them,
Because, my lord, the
is it?
last,
The trial court could not have relied upon it.
that is why, my lord, my last argument would again be, my lord, that the doctor says that 12 to 18 hours, then had the lady been on the night, have killed the, my lord, deceased, my lord,
We
then
don't know.
it would have been 36
don't-
hours, my lord.
we-
It would have been 36 hours by the time the
Mr.
examination-
Counsel,
Yes, my lord.
why do you presuppose that he was killed at night? Why do you presuppose that that person was killed at night?
My lord,
From where do you why do you presuppose that? Where's the facts supporting your theory that he was killed at night? Could have been killed in the morning, could have been killed at 11 o'clock, could have been killed at 12 o'clock. A fire was filed at 1. So
Then, my lord,
why you,
my lord, then, my lord, my only submission before this honorable court would be that I would commit a crime only at the heat of the passion while we had quarrel, my lord. After 2 hours, my lord, my temperament would not be that similar to the extent which at the time of trial, my lord, the quarrel, my mental state would be. Because after 6 to 7, because it is not, all the witnesses have said that every day often they quarrel, but often this was never happened. So, my lord, the reasonable explanation would be that, my lord, on the heat of the moment only, I'll try to kill out a person, not thereafter, my lord. Because earlier also there were quarrels.
how do you know that it happened in the heat of the moment? That is your speculation. You're speculating. That is, you are that's all guesswork.
My lord, being an amicus, whatever is there on record, my lord, I can only submit from.
That is
the
what,
record
then
which is there
submit what's
available.
on record. Don't guess. Don't second guess what might have happened.
That is what, my lord, because my lord, even if my lord, the PW says that he, in the morning hours or thereafter, they did not hear
Anyway,
any
let
noise,
us,
my
let,
lord.
let us hear, let us hear
Yes,
the
my
addition.
lord, my lord.
Yes, madam. Yeah, yes,
All the prosecution witnesses, the cases that the accused and the deceased used to live together. There was no third person at his residence. And the evidence of PW3 proves that the accused was very much present during the relevant point of
let
time.
us see
His
PWC, what does
immediate
it say?
neighbor, PW3, Sonu Nayak. Page 11.
Yes,
I know the accused Regina Kormokar as she resided near my house. I know the complainant also. He too resides in the area where I reside.
in the area means how big an area?
Lordship, this person, Somu Nayak, may I see the sketch map at page 59? 59B. Immediate vicinity, AB.
No, no,
A is
no.
the Lordship, B.
You see, just because the drawing looks they're nearby, doesn't mean that they have got to be just inches away.
Indicates to your house of
You see,
friends.
this is not an objective drawing. You see, this is very subjective.
Lordship, but
It could be 50 meters away,
oh, it might be,
25
it might
meters
be.
away,
The
75.
sketch map doesn't disclose
Yeah.
anything, my lord. But this witness deposed that the accused person, he heard a noise from his residence, that they quarrel. Every day it's a everyday affair, your lordship.
No?
But he heard quarrel, and if the accused person in Trivandrum states that there was a quarrel but the previous night, then thereafter she left from his residence. And the reason for leaving the residence is, your lordship, may kindly have a look at 313 statement, your lordship. Answer to question number 1 at page 16. It is incorrect that there was a quarrel between us on the previous night. My husband, Haradhan, being drunk, drove me out of the residence, for which I took shelter in the residence of Mohesh Bauri. I do not know, therefore, how death occurred to him. On the next morning, when I went to my home, I found my husband in injured state. At that time, he was unable to speak anything. He was under the influence of alcohol. Then I called the villagers. Then, your lordship, answer to question number 2. I do not know how my husband died, as I was not present in the residence at that time. I also found the floor of the room was besmeared when I came to my residence on the next morning. Then, your lordship, answer to question number 5. I am innocent. I have not committed murder of my husband as alleged. On the previous night, the accused a large amount of alcohol. Your lordship will kindly note this part. The accused had a large, the victim would have, my lord, had a large amount of alcohol. I advised him not to have alcohol. Then he rebuked me and went out. After a few minutes, he again came with 2 bottles of country liquor. I told him to have dinner instead of liquor. At that point, he caught hold of my nape and gave a push. He drove me out from the residence, for which I had to take shelter on the residence of Mohesh Bauri. On the next day morning, when I reached home, my husband was lying on the ground. I noticed injury marks on his forehead as well as shoulder. As he was sweating, something is missing here with a cloth, he went out to call villagers. I found Meghnad Rajput on the way and asked him to wait for some time beside my husband, and went to call president. When I returned back, I found my husband died. Now I take your lordship to postmortem report whether any alcohol was found on his stomach, your lordship. Postmortem report, page 42. Lordship, page 46, abdomen.
Yes,
Serial number 5.
yes.
Healthy filled with digested food material and gases. Healthy filled with fecal matters and gases.
So,
There's no incident that he consumed alcohol. This is the first
there
explanation.
huh? You see, there is no evidence that there is water also. He must have drunk water while having food.
Lordship, but
What?
yes, but regarding whether that explanation is given is
No,
false, my lord.
Madam, this is a liquid.
My lord.
This is a
But there has
liquid.
to have, my lord.
No, unless you do a test for alcohol, how will you know that it's alcohol?
Hmm. It's not there, but the explanation meant to say, the explanation given by the accused person is false, your lordship. that he
No,
was drunk.
why false?
Lordship, but
You
there,
you see, alcohol gets absorbed into the bloodstream through the walls of the stomach. It gets broken down by the liver.
but on
And
examination, my
you
lord.
see, supposing now, when somebody has food, before or after food also, people drink water. There is nothing stated by the doctor that there is water. What, does it mean that that person didn't drink water?
Your lordship will not presuppose like water, he had water, because sometimes only.
Who is going to check in the stomach whether
Lordship,
he
I
had,
have found like cases wherein, your lordship, the.
did you ask the
The
doctor?
contents of alcohol on examination is found, my lord.
Huh?
Contents of
Madam,
alcohol
as
is
per-
found under examination of the dead body while autopsy is done, your lordship.
No, did you ask the doctor if he had conducted a test to determine whether he had consumed alcohol or not?
That is not. there.
Then why didn't you ask him whether he had drunk water or not?
That's not there. I mean to say, she was very much there. The presence of her well proved by PW3, the explanation given by her, because under 106 she ought to give an explanation because she's a resident of the same, they used to reside together. An explanation given by her is false, my lord, which is not believable, which negates by the postmortem report that he had alcohol and he thrashed her out. And prosecution could able to prove the presence of the victim
Okay,
along with the
okay.
accused person.
Okay, madam, let us see when the examination was done.
Yes,
At page
examination.
43.
Yes, my lord. Dispatch at 10:30 and 10 a.m.
No, examination, do it,
Examination 2 p.m.
2 p.m.
Yes.
On,
On 10/8/18.
okay, 10, keep that in mind, 10, 8, 18, 2 p.m.
Yes,
That means in the afternoon.
yes.
Now come to the part where he says that the cause of death.
This one, my lord, opinion part.
47, madam. 47.
Yes. Time since date 12 hours to 18 hours. But that column in the, apart from the opinion part, that column is missing in the postmortem report. In some of the postmortem report, it's there, specific column is there. Your
This is
lordship.
in the evidence or not?
Yes.
This is in the
My lord,
evidence.
my lord,
Now, you didn't confront
My
the witness with
Yes.
regard to that.
my lord.
So we have to take it as 12 to 18 hours. Now just calculate, forget 12 hours, calculate 18 hours backwards from 2 p.m. of 18, 18, what was the
Two,
date?
10/8.
Ah,
2
Yes,
p.m. of 10/8.
10/8.
Lordship, it will be
10/8.
6 p.m. of 9/8. 6 p.m. 18 hours. 2 p.m. of 10/8, my lord.
no. 2 p.m.
Of 10/8.
of 10, 8 will be
10/8.
how many hours?
No, Lordship.
No, no, just say, there are 12 hours, there are
Yes,
24 hours.
yes.
So 1 to 12 is 12, and then 2 p.m. will be another 2 hours you have
2
to add.
a.m.
So
2 a.m. to 2 p.m. is 12 hours. Then Lordship, it will be 6. If I'm not wrong, I'm very poor in calculation. It will be 6
no,
p.m.
I'll give you a very
Yes.
easy way to understand.
Yes,
Now it is 2 o'clock today.
yes.
How many hours have been completed today? 1 to 12, morning,
No,
1 to
yes,
12, so
yes,
12 hours.
Yes.
Another 2 hours you add, 2 plus 12 is how
14
much?
hours.
14 hours.
Yes,
So here also 14 hours gone on 10.
yes, yes.
18 minus 14 is how many hours left?
18 minus 14 is 4 hours left.
No, 4.5.
Yeah,
Four.
yeah.
Four.
Very poor in mathematics, my lord.
Anyway, so 4 hours are left. Now, coming to the earlier date.
Yes, on 9.
So the date prior to 10th will be 9th.
Yes,
9 days, in the 9th, there are 24 hours.
yes.
You minus 24, you minus 4 hours out of 24. 24 minus 4 will be how much?
20.
20. Now 20, the 20th hour will be which hour? Will it be
28 hour will be,
12 will go?
yes,
Out of 12, another 8 hours are left. So it will be 8 o'clock.
8.
So the death should have occurred actually on 8 p.m.
But
On
your
9th,
lordship,
on 9th.
taking
But
into,
according to the prosecution, the death occurred in the night of between 8th and 9th, at that night,
the
so that
opinion
we-
of the doctor, lordship,
Is
your
wrong.
lordship will,
according to you.
maybe my evidence, our officer, prosecution evidence, witness. But your lordship, it's a conclusive, it's not the conclusive proof.
Enough. Okay.
Because
Okay.
other
So-
witnesses are also there, they,
So we,
they
so,
are,
so if it's not conclusive proof, we do not know when he died.
yes. But the circumstances, your lordship, that there was quarrel. She was very much present. In Trivandrum, she says she was there.
No,
Qua-
no.
Quarrel had taken
Quarrel
place.
that doesn't mean that you need to kill. A husband and
Lordship,
wife,
it's
there's
true.
some
Lordship, it's
some
true.
husband and quarrel.
But she said, because of the quarrel, she was driven out by the victim. She was driven out and she took shelter in the residence of one Mughal Rajput, one Mahesh Mauri, and one Mughal Rajput.
So-
Two persons, one she made and one she took shelter. These two persons not examined. She could have brought as a lordship, as defense witness, my lord. She did not bring.
But then you cannot base your case on the weaknesses of others. That's her weakness, maybe.
Lordship,
then
it's
that-
the exception to the circumstances evidence because the case, what the incident had taken place inside the house. Lordship, because
So-
the
so-
prosecution has less burden than any other case of
No,
circumstantial
no,
evidence.
Madam, but the problem is understandable when they don't give an alibi or they don't give reasons.
Lordship,
then we
alibi has to be
understand your-
substantiated by way of proof, my lord.
No, but
There
then-
was no defense witnesses who have been
No, no,
examined.
But then, where is the consideration of the explanation by the trial court? The explanation given by the
In Trivandrum.
appellant.
Yes, my.
was
Yes,
it considered by the
Lordship, may I
trial court?
see? Lordship, may I take your lordship to para 35? May I read it once?
Page?
Page 35, para 35.
Yes.
My discussion would be complete if I leave a few other aspects undiscussed. There is admittedly no recovery seizure of weapon of offense in this case. It appears from the evidence of PW6, the IO of this case, that at the place of occurrence, he found the dead body of the deceased with a wound on the head, and he noticed that the floor of the house was besmeared. He has not stated anything about the presence of any incriminating article at a place of occurrence. There is, however, a mention in the charge sheet that during the inspection of the place of occurrence, no article connected involved with the case, which is what seizing, could be found at the place of occurrence. No matter the weapon of offense could not be recovered seized in this case, the prosecution has nonetheless succeeded in proving the case beyond reasonable doubt on the strength of chain of circumstantial evidence, which is consistent only with the hypothesis of the guilt of the accused. The next aspect is that, as per opinion in the postmortem examination report, the approximate time since date is 12 to 18 hours. The postmortem examination was done on 10/8/18 at 2 p.m. If the time is stretched back to the maximum of 18 hours, the time of date as per the postmortem opinion could come around 8 p.m. on 9/8/18. But in the present case, the occurrence was of the intervening night of 8/8/18 and 9/8/18. And as per the testimonies of the
Just pause a minute.
last, yes, Your Lordship.
The trial court says that in the present case occurrence was of intervening night.
Yes.
On what basis trial court is making this observation?
On the basis of the lordship FIR.
Trial
because
court is giving a finding that in the present case, occurrence was of the intervening night of 8,
8 and 9
8 and 9,
Yes.
differing from the medical opinion. On what basis trial court is basing its opinion that it is of the intervening? How trial court came to know? What is the basis? Actually,
Lordship, may I get something? I'll read out. Lordship, but in the present case, the occurrence was on the intervening night of 8/8 to 9/8/18. And as per the testimonies of the PWs, the victim Haradhan Karmakar was found dead in his house on the following day, on 9/8. The accuser stated in her statement under section 313 that on the next morning, she found her husband lying on the ground and she noticed injury mark on his forehead and shoulder. And as she went out to call the villagers, and when she returned back, she found her husband dead. In view of this difference between the evidence of PWs and medical evidence regarding time of death, the evidence of the PWs has to be relied on, and I do so. One more aspect as regards the inquest on the dead body of the deceased, which is done on 9/8/18 at 4:30 p.m. It is in the evidence of PW6 that he informed the circle officer, but she was unable to be present at the place of occurrence. So he himself made the inquest over the dead body. It, however, appears that the inquest was done in a perfunctory manner. In the inquest report, IO did not even mention the descriptions of injuries found on the dead body, but mentioned in the opinion portion as revealed by witness is dead due to injuries sustained caused by his wife Regina. We mentioned here that the accused herself has stated in her examination under 313 that she noticed injury marks on the forehead and the shoulder of her husband. So when the injuries were very much there on the dead body, the description of the injury should have been mentioned in the inquest report as recorded so and so. But that was not done. To my considered view, that can be basically considered a defect investigation. That's not the defect.
not there. What was the time of death?
Lordship, if your lordship calculates, then it would be like after filing of the FIR. I mean, I may be wrong, my lord. The FIR was filed on 9/8/18 at 4 p.m.
That's why we are saying in the case of the walking dead. Another aspect,
Right.
you see, the weapon was not found. Is there anything stated by the IO as to whether he made any inquiries with regard to
Weapon,
where and what was the weapon?
nothing.
Even to the, huh? He did
Nothing,
not
Your
even attempt to find
No,
out the
no,
weapon.
no. Nothing. But as he has said, there is a quarrel. If your lordship,
Quarrel to happens. Some couples quarrel every day, maybe. Some couples quarrel once in a blue moon. And I don't know, some couples may never have quarreled in their life. I haven't met them. I don't know. But I don't know. Marriage is a compromise, everyone knows. In normal circumstances, there are quarrels. Of course, when there is drinks involved, probably they quarrel every night.
aggravates.
Probably this lady also might be drinking with.
Might be,
the-
might be,
might
because
be.
they
So,
belong to.
yes, and they are
Sapa.
living together.
garden.
They are also of, don't belong to the same, but and
Tea,
not,
tea, tea
they
garden,
may not be
Tea garden
belonging to
members.
the same
Tea garden.
religion also.
maybe.
I don't know. Do they belong to the same religion?
Yes, madam. Both are Bengalis, madam. And they are tea garden laborers, madam.
So in any event, there has to be, I mean, all the evidence or circumstantial evidence should only point in one direction.
There was somebody else.
No, point in one direction, meaning that there can be no other hypothesis except the guilt of the
Accused.
accused.
That is your lordship. She
Ah,
has also
now-
admitted.
But no. But then the evidence does not point only towards that aspect. It gives so much of leeway to consider this or that different kind of hypothesis.
Lacuna is there.
Then as per the Supreme Court judgment, with regard to how a case should be decided based on circumstantial evidence, can we say that it unnervingly points only to the guilt of the appellant?
But your lordship, if your lordship keep it apart the time factor, then your lordship, although prosecution evidence doesn't specify as regards the timing part, but if your lordship considers the evidence of PW3, she was present, she herself in Trivandrum States, she was there, there's a quarrel, my lord. So out of that, and these two witnesses never been examined, they were material witnesses. One,
No, you cannot base.
even one witness, my lord, on
Prosecution
whom,
cannot base its case on the weakness of the
yes, true, your lordship, true.
case of the other.
True, my lord. But plea of alibi, she has left the house as because she was driven out, and she took shelter in the residence of one Mohesh Bauri. But that fellow has not been examined.
We don't
When
know.
plea of alibi is taken, lordship, there has to be
Now,
sufficient proof.
you see, as the prosecution, as the investigating officer, the first issue, one of the very important issues is the weapon. He's kept completely silent about it.
Nothing, lordship. But non-recovery weapon, lordship, other day.
No,
I have
not
cited
non
one.
not.
Even no
He
endeavor
should
has
have
been made.
asked her
Yes.
whether what weapon she used.
Yes,
Where is the weapon? There is nothing.
nothing.
He doesn't say that she used a weapon or something. Where is his evidence? Or where is the evidence that she used a certain kind of weapon? Nothing. And in a murder case where there are so many injuries as per the medical report, the first thing that should have come to his mind was what weapon was used? Where is the weapon?
Blunt injury maybe because of, my lord,
Blunt injury, what? He fell down 20 times.
maybe they was fighting, they were quarreling, my lord. Hitting you. She was,
And he fell
He
down
was hit.
20 times this way, that way. You see the report, so many blunt injuries, except for 12, 15, 17, so. How many injuries are there? 17 injuries.
17.
So he must have fallen down at least, I don't know, quite a number of times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Every time he got up, wife must have given him a box or something, fallen down, again got up, again another blow.
my lord. I leave
Is
it
it-
to your
is
lordship,
it-
my
is
lord.
it-
If your
no,
lordship
no.
wants to give the
No,
benefit that,
no, it's not that I want to give. We just want to look at it in the right perspective.
Right.
Where is the attempt made by the IO to say that these abrasions were caused by something
Right.
or by, some on the basis of his evidence collected by him,
lordship,
that something had happened?
my lord.
Or is it that the wife had, wrestled him to the floor around 11 times and then he banged his head 11 times? I don't.
Even he received injury on his skull.
That's
Hematoma
what I'm
over there.
saying. Or WWF or WWE or something like that. Anyway, that's all.
Lordship, one factor, because it's a exception to circumstantial evidence, because it's a crime has been committed inside the house. Lordship, so initial burden is on the prosecution to prove, but burden is less, lordship, mean to say,
Correct,
it's on the
correct. No,
defense
no,
to-
no, I understand. Within the four walls
Yeah,
of our
yes,
house,
yes.
what happens that 106 comes
Yes,
into play?
yes.
That's what you're trying to
Yes,
say.
yes, my lord. But here it's supposed, because she gave an explanation, because she gave in 1313 that she left the residence of the.
And that was not discussed by the trial court. Then why should the appellant suffer due to the fault of the learned trial court in not discussing as to the probability of the alibi stated by the appellant? That
Yes,
some
but your
discussion
lordship,
is
the
required.
appellate stage also, if learned trial court did not discuss into the matter, in appellate stage also, your lordship may appreciate and reappreciate the evidence and record, my lord,
Yes,
and
yes.
come to a finding.
Yes, yes. But then we also have to find out whether the basis for coming to a finding of guilt by the learned trial court was correct. Besides, that is only one of the points.
Right.
There are so many lacunas here. 17 injuries, and the IO doesn't bother to ask the appellant as to how this had happened. What was the weapon used? Where is the weapon?
May I check once if any question was put to her?
No, if there is nothing in the evidence, how can that question be put to her in the first place?
Correct, correct.
That is there, but in any lacuna in the prosecution,
No,
The
no, no,
defect in
madam, madam, no,
investigation.
no. There is a different issue. This is where you have got to prove your case beyond all reasonable doubt.
That's true.
It's not the other way around. It's not that the accused will have to prove that she's innocent beyond all reasonable doubt. It's the other way around. It's not your section 54 of the NDNPS Act or something like that.
my lord.
And my lord, the learned court below case was conducted by a legal aid counsel, and my lord, these appellants, my lord, are from a lower status. They don't know that if I take a plea of alibi, I need to adduce evidence. She was in jail. She was never on bail, my lord. So, my lord, those parts, my lord, the correct, my lord. My lord, what I'll say is that, my lord, the advocate could have taken an endeavor to call or at least contact the Mahesh Bawri to give a defense statement. Then, my lord, things could have been different, my lord. She had a legal aid counsel only in the learned court below, also trial court, my lord. So, my lord, sometimes, my lord, these data people, they don't have that much of knowledge that they'll bring a person to defend in their defense statement, my lord. They need to adduce further evidence, my lord. So, my lord, to their understanding, my lord, in
Okay,
theory,
okay. We're just beating around the bush. Now you have finished your part. Now our part starts. Heard Mr. A. Tiwari, learned amicus curiae. Also heard Ms. B. Boyan, learned additional PP for the state of Assam. This appeal has been preferred against the judgment dated 8/7/2020 passed by the Court of the Additional Sessions Judge Dibrugarh in Sessions Case number 184/2018, by which the appellant has been convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life with a fine of ₹1,000, in default to undergo rigorous imprisonment for another 3 months. The prosecution case in brief is that an FIR dated 9/8/2018 was submitted before the officer in charge, Moran Police Station, Dibrugarh, stating that was submitted by PW2, stating that at around 1 p.m. on 9/8/2018, he saw his uncle, namely Haradhan Karmakar, lying dead in his residence. Further, first of that his uncle had been living with the appellant as a live-in partner, as no marriage had been solemnized between them. Full stop. The FIR also stated that PW2 came to know that his uncle and the appellant used to quarrel with each other often, and that on the night of 8/8/2018, a quarrel took place between them, whereafter the appellant left the house and stayed in the house of some other person. Also, seeing injury on the head and other parts of the dead body of his uncle, it appeared that the appellant had killed his uncle. Full stop. Consequent to the FIR, Moran PS case number 219/18 under section 302 IPC was registered. Full stop. Next paragraph. After investigating the case, the IO submitted his charge sheet, wherein he found a prima facie case under section 302 IPC against the appellant. Charge under section 302 IPC was framed against the appellant on 5/2/2019, to which the appellant pleaded not guilty and claimed to be tried. Full stop. Subsequent to the recording of evidence of the prosecution witness, 6 prosecution witnesses, and examination of the appellant under section 313 CRPC, the learned trial court convicted the appellant under section 302 and sentenced her, sentenced her to undergo a rigorous imprisonment for life with a fine of rupees 10,000, in default RI for actually 1,000, not 10,000, 1,000 RI for 3 months. The learned counsel for the appellant submits that the learned trial court has convicted the appellant basically on 3 grounds. Firstly, that the circumstantial evidence pointed towards the guilt of the appellant. Secondly, in view of the last seen theory, wherein it was shown that the appellant and the deceased had been living together and had apparently been, they were not seen by anybody. What have I said?
Secondly, in view of the last seen theory, wherein it was seen that the
Wherein
appellant
it was accepted. It was an, it was a, wherein it was known that the appellant and the deceased were living together, comma. The only assailant could have been the appellant. Full stop. Thirdly, no reasonable explanation had been given by the appellant with regard to what she had been doing at the relevant point of time. To prove that she had no hand in the death of the deceased, comma, as required under section 106 of the Evidence Act. That's all.
Yes.
Full stop. Next paragraph. The learned counsel submits that a perusal of the time of examination of the body of the deceased by the doctor, bracket PW1, and his opinion that the death had occurred between 12 to 18 hours earlier, prove that the death of the deceased could not have occurred during the night of 8, is it? The night of 8/8/18 and 9/8/18. First time. Further, the explanation given by the appellant under section 313 CRPC showed that the appellant was not present in the house of the deceased on the said night, as she had been driven out from the said house by the deceased. In support of his, the learned counsel for the appellant has submitted that the circumstantial evidence which was required to be present. It's the learned counsel for the appellant submits that in matters of circumstantial evidence, comma, the conditions laid down by the apex court in the case of Sharad Birdi Chand Sardar versus State of Maharashtra 1984, 4 SCC 116 have to be present to prove a case on the basis of circumstantial evidence. He also submits that as the appellant has given her explanation with regard to the circumstances under which she had parted company with the deceased on the night of 8/8/18-9/8/18, comma. In terms of section, not comma, in terms of section 106 of the Evidence Act, comma. The prosecution was to have proved the case, proved the guilt of the appellant. Comma, which had not been done. So. Next. No, continue. So he accordingly submits that the impugned judgment no, he accordingly submits that as the learned trial court has convicted the appellant without there being any circumstantial evidence to prove the guilt of the appellant, comma, the impugned judgment should be set aside. Post up. Ms. B. Bhuyan, the additional PP submits. Yes, madam, what do you submit?
Lordship, I have placed two citations. One, Trimukh Bharti, Lordship is aware of.
Huh?
Trimukh Bharti Kirkan judgment. One on medical evidence. The opinion given by doctor, medical need not be the last word on the subject. 2022 8 SSS which could say that book I have not brought just now. Okay.
We have heard you, but I don't remember what is your major point.
Lordship, the presence of the accused person is well proved from the evidence of PW3. She heard the noise.
Submits that the presence of the appellant in the house of the deceased is proved by the evidence, and as such, it was only the appellant who could have committed the crime, or who could have caused the death of the deceased.
PW3 heard the quarrel which has taken place on the previous night.
So secondly, the evidence of PW3
His neighbor.
being to the effect that he had heard the quarrel between the appellant and the deceased on the night of 8/8/2018 and
previous
9/8/2018. Comma,
And Lordship, one more aspect. All the witnesses have deposed. Accused and the deceased used to live together and there was no third person in the residence.
and they never had visitors. And they
Yes.
also never went to the house of others, is it?
That is not there, but both of them used to live together.
They live like hermits. They're very happy in each other's company.
Lordship and Srivanti
Never
also
get-
stated.
Never get tired of seeing each other's face.
Maybe, my lord. That's why they quarrel so much. They used to quarrel,
Maybe, yeah.
maybe.
Maybe seeing each other's face too much. Happens.
Well,
If you see somebody too much, then you become a bit too familiar, and then yeah, happens. Yes,
Secondly, the evidence of PW3 is to the effect that he has heard the quarrel between the appellant and the deceased on the night of 8/8/2018 and 9/8/2018.
No, 8/8/2000.
313 also-
9/8 was dead already. 8/8/2018, and as such, the only no, and
313 statement also.
in view of the fact that the evidence of the other witnesses showed that the deceased and the appellant lived together, proves the fact that it was only the appellant who could have been the perpetrator of the crime.
And in
What's
313, she has also deposed, she was there was a quarrel, and thereafter she left the house.
First up, she also submits that the appellant, having admitted to the fact that she had a quarrel. Where does she say
Yes,
that she had a
313
quarrel?
statement, answer to question number 1.
Where does she say she said that she had a quarrel?
Previous night she had quarrel.
Where does she
Lordship,
say that?
Lordship, answer to question number 5, para 17,
What does
case
she say?
17. I am innocent. I have not committed murder of my husband is alleged. On the previous night, the accused had a large amount of alcohol. I advised him not to have alcohol. Then he rebuked me and went out. After a few minutes, he again came with 2 bottles of country liquor.
So is that a quarrel?
Because of
Did she-
because of the
No,
liquor. They had,
Madam, please read it again.
my lord.
Let us not put words into their
No,
mouth.
no, rebuked me. There was a like
Rebuked. He did not rebuke, he rebuked
He
her.
rebuked, whatever may be, your lordship, there was, he rebuked, the victim rebuked the accused person, and she said there was alcohol, due to alcohol. But my submission is that no alcohol was found in the
No,
postmortem.
madam, you said that, he said that there was a quarrel. But
About
she
quarrel,
has
she
not said,
said,
she has not said that we had a
about
quarrel.
quarrel, when the question was put, my lord, question number 1, PW2 Sujit Karmakar deposed in his evidence that on the fateful day his uncle has found was found in the residence where you along with the deceased resided. The witness also stated during your stay in the state that both of you quarreled regularly. What do you say in this regard?
So what did
Her
she say?
answer,
Ah,
it is incorrect that
it is
Lordship,
incorrect
thereafter.
that,
there was a quarrel between us on the previous night.
It is incorrect that there was a quarrel means what there was a quarrel.
No, that part, it was put to him,
to
but
her.
she said, put to her, but she said previous day there was quarrel, not on the same day. But her answer to question number 5, she said the victim rebuked her. And all the witnesses of deposed, they used to quarrel regularly.
So she never said that there was a quarrel. She said, you see, what is a rebuke? Rebuke means when one person speaks of another person, maybe in a bad way or, looking down. Right. But it's a one-way traffic. It's not a two-way traffic. When there's a rebuke from one person to another, then okay, you can say it's a quarrel. But when it's a one-way traffic, there's no rebuke.
Whatever, Lordship, but one more aspect, all the witnesses of deposed, that they used to fight regularly. They used to
That
quarrel
is a different
regularly.
issue.
So that's why
other
even
witness- but-
after hearing, they did not come
say
out.
that. But she did not say that.
She
Others
did
might
not
have.
say.
Ah.
Previous day she had quarrel.
Yes.
And alcohol content was not found in the postmortem, my submission. No, my submission be recorded.
I know, but it shouldn't be recorded, because I mean these things. There's a judgment of the apex court in I think 1973. Which says that for blood, you're going to have an injection that test done by taking out the blood. It is that difficult. Just because alcohol is there in the stomach, even if it's there, how will you know it's alcohol? Supposing it is there, madam, how will you know whether it's alcohol, acid, or water?
On dissection, when autopsy is done, your lordship, sometimes the
Unless you
smell of
do a
alcohol.
test on the liquid, unless you take it out in a syringe and put it through some chemicals, you cannot.
But I have seen, my lord, in the report, there's a mention like alcohol like thing materials are
If they
found.
do the
If they
test,
do,
if they do the
that's
test,
correct,
if they
that's correct.
don't do the test, you cannot know, madam. That's what we're saying.
Let my submission will be recorded. I'll refer to judgment, Your Lordship. Timuk Maruti and one more, Virendra Singh, 2022, defect in investigation and opinion of the doctor should not be taken as a gospel truth, my lord. As the last word of the court should not take it as the last word. I have given the citation 2022 8 SCC.
Quarrel.
No, she did not admit. She did not admit. Okay, submission, okay. Okay, he submitted that she had a quarrel, and having admitted to the fact that that the appellant had a quarrel. No. She also submits that the fact that the appellant had admitted to having had a quarrel with the deceased was also one of the pointers to the fact that she was the perpetrator of the crime. Correct, Gustav? She also submits that the post-mortem report did not state, did not make any report with regard to whether there was any alcohol.
She has stated in 313, on the previous night, the accused had a large amount of alcohol, and in that context, I am making submission. If your lordship considers this aspect, that she had alcohol,
He had alcohol.
yes, that the no contents was found in the postmortem report.
How does it matter if there was alcohol or not? How does it
Due
matter?
to alcohol, there was fight, your lordship, and he rebuked.
Can
She
be
went out.
due to Coca-Cola also there can be fight.
There can be, no, my lord, but contents has to be there. My submission
No, I'm
has
just
to
saying,
be
I'm just
there.
saying, what is the relevance of it? That's what I'm
My
trying to
lord, I meant to
understand.
say, because of the rebuke of the victim, she left. She, according to her, she left and took shelter in the residence of somebody else. But on whose residence she took shelter, that person was not examined as a defense witness. Neither alcohol was found in the postmortem report. That is my submission,
No, but I'm just asking,
my lord.
since you want that alcohol to be there,
Yes.
what is the relevance supposing alcohol is there? And alcohol, supposing alcohol is there or not there, what is
Yes,
the relevance of
yes,
that?
because if alcohol is not there, there would not have been rebuke on the part of the victim. She would not have left.
Are you sure?
Because, lordship, because so she was very much there in the residence, she committed the crime. I
So-
mean to say, she did
So,
not go anywhere.
so only persons who drink alcohol rebuke.
No, my lord. I didn't mean to say, she was very much there in her residence. Defense witnesses was not examined as to the plea of alibi taken by her. Because of the rebuke, she left, took shelter. So she was very much there in her
Okay,
residence.
okay, where are we?
She also submits that the postmortem report did not make any report with regard to whether he had any alcohol.
Whether the deceased had any alcohol in his stomach,
As she has stated in her 313 statement that
as stated by the appellant in her statement made under 313 CRPC.
so if she makes any false statement in 313 in the case of circumstantial evidence like this, it gives additional link to the
Was
circumstance.
she confronted with the statement? Was she confronted with the doctor's report? That look, doctor's report does not make any mention with regard to presence of alcohol in the stomach of the deceased. So that means what you have stated is wrong. Was she confronted?
That is not.
I'm not confronted. I mean, was the doctor confronted?
So 313 statement, if she gives additional, lordship false statement, it gives additional link to the circumstance. my God.
Anyway, right. Where are we? Okay, she further, the additional PP further submits that though the appellant had stated in her examination under section 313 CRPC that she had been driven out of the house by the deceased and she had taken shelter in the residence of one Mohesh Bauri, Moheshbowri. The said Mohesh Bauri was never examined as a defense witness. Further, though appellant had stated that she had found Meghnad Rajput on the way and asked him to wait for some time beside her husband while she went to call the president of the village, village, comma. Meghnad Rajput was never made a defense witness. Anything else?
So since
Yes, I did. Where is the petition? Okay. This one. Virendra,
Virendra, it is as regards medical opinion, as regards defect in the investigation.
which para?
My diary says defect in the investigation, para 47, para 53. And regarding the medical evidence, para 30, 31, 32, and
My
34.
God. No, what do you want to say, madam? What is
Expert opinion, my lord, he says time since date 22 to 24, that part, my lord.
12
So,
to 18 hours.
yes, 12 to
Yes.
18 hours.
Then
So that factor, your lordship will not take it as a last word of the expert.
Not
Lordship
the
will
last
take into account the
so which
other
para,
factors.
which para is that?
Para 30, 31, 32, 34,
Para 31.
30, 31, my lord.
These cases that has been mentioned is with regard to what? The state of Haryana versus Bhagirath is with regard to what case?
I do not have to.
No, you see, you are relying upon certain judgments
Yes,
of the apex court.
there its reference is given.
With regard to what? Is it with regard to POXO, with regard to
Mine
death?
is written as POXO, your lordship, but that Xerox copy, I had only one copy, your lordship.
These cases that you are relying upon, we want to know, you see.
It's regarded as regards the opinion of the doctor, my lord.
Opinion is, but you see, this is not with, this is with regard to the injuries sustained.
Regarding the opinion of the expert.
Yes, so whether it is with regard to the time of death or with
No,
regard
but
to the.
lordship, because in the column, it's not written as that specific column is not there. But in the opinion part, he has written time since date, 12 to so and so hours. On the basis of that, I'm saying, my lord, opinion, regarding the opinion part.
So what we are trying to say
I mean to say, your
is that
lordship,
the medical report
regarding the
and
time,
the evidence is not the last word on
Yes.
when he died.
yes, if your lordship considers the time factor, that this disease died long before. Or maybe
We do
after
not
filing,
know. We do
maybe
not.
after filing, that is not tentative. Lordship tentative time doesn't come out from the evidence on record. But if your lordship considers this medical evidence, it says 12 to 18 hours. So your lordship may come to a finding that it is within 12 to 18 hours. If your lordship relies on the evidence of the doctor.
No, I agree. But then as per the judgment of this court, in
My
this Supreme Court,
My lord,
now where does it talk?
may
Where
I
does it
see
say?
it once, my lord? I don't have. a
Where does
copy.
it say that the time of death given by a doctor in his post-mortem report should not be relied upon or is not conclusive or something like that.
Time
Unfortunately,
per se may not be there, my lord, but opinion in, it's on the opinion column. Opinion column, they
opinion
have,
with regard to what? Correct. That's what. That's what, it depends upon what. is, You see, like we were just saying, the cases that has been relied upon here and the opinion given by the doctor would depend upon the facts and circumstances of that case.
each case.
Now, you show us that this judgment is directly relatable
No,
to the
no,
issue here.
no, no.
You cannot
No,
have a
no.
broad
Issue as regards the opinion of the doctor.
opinion of the doctor with regard to what? With regard to, there's so many
No,
factors to
no,
be, with
maybe,
regard
my
to the
lord,
death.
but you know, whatever may be the opinion, your lordship will not take it as the last word, my lord. I mean to say, Supreme Court says, my lord, may I see your lordship, the
No, no.
particular paragraphs?
No, we have got, what the thing here, the opinion given by a medical witness need not be the last word on the subject. Such an opinion shall be tested by the court.
Yes,
Now,
yes.
in what was the facts and circumstances on the basis of which this observation has been made in this case? Because if you remember, the apex court has held that a judgment is only an authority for what it decides.
Yes,
Okay,
yes.
so a little difference in facts
My
makes
lord.
the presidential value of a decision less. Okay, so basically what it says is that a judgment of the court cannot be treated to be like an ODBS Euclid's theorem.
My lord.
Okay, that means what applies here will not automatically apply here.
No, no,
So that is why
my lord.
you have got to show us that the judgment that you're relying upon is exactly to the point
No,
in
may
this
not
case.
be, may
So
not be
that is what
exactly,
we
it's
cannot
not.
take a broad
No,
consensus.
no. My meant to say, my lord, because out of the prosecution witnesses, it is not discernible that as regards the time of death, my lord. Apart from the medical evidence, a medical doctor, he opines that time since date is 12 to 18 hours. So your lordship will take into account the other factors also, other evidence also, my lord. Will not take it as a last word of the opinion of the doctor.
Okay, we'll record your submission on it. Okay. The additional PT also submits that the opinion given by a medical doctor need not be the last word on a subject. And such an opinion has to be tested by the court. First of all, in this respect, she has relied upon the judgment of the apex court in Virendra versus State of Madhya Pradesh, reported in 2022 8 SCC 668. Anything else? One more judgment you were saying?
Timur Marathi, famous
Give me, yeah, show me.
case.
We don't.
2006 10 SCC 681.
Yes. Which para?
Para 18, then 20, 21,
Para 15.
15 is also there. Where an offense like murder is committed secretly inside the house.
You're right. She also submits that where an offense like murder is committed in the secrecy of a house, the initial burden to establish the case would undoubtedly be upon the prosecution. But the nature and amount of evidence to be led by it to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. Full stop. In view of section 106 of the Evidence Act, a corresponding burden would fall on the occupants of the house in which the offense took place. to give a cogent explanation as to how the crime was committed. In this respect, she relies upon the judgment of the apex court in Dash versus Dash, reported in 2006-10 SCC 681. She accordingly submits that as no cogent explanation has been given by the appellant in an examination under section 313 CRPC as to where she was and how the offense had taken place, where she was at the time the offense took place. The same pointed to the involvement of the appellant as the perpetrator of the crime. She accordingly submits that the circumstantial evidence having pointed to the guilt of the appellant, the impugned judgment passed by the learned trial court should not be interfered. So we have heard the learned counsels for the parties. Okay, hearing concluded, judgment reserved. Okay.
No, Lordship,
Feeling
regarding
highly
plea of
tired.
alibi, no defense witness. Lordship already observed. me.
I've already stated that, okay, right. She also submits that though she had, that though the appellant had an alibi, as can be seen from her explanation given under section 316. No defense witness had been produced by her. Hearing concluded, judgment reserved.
If you apply your lordship.